listing of a IA, my lord. File for correction of an order, my lord, past yesterday, my lord.
It may come before this court only, no issue. You make a mention before registry. We are not taking any mentioning matter. You make a mention before either before registry or before court number 8.
Order was passed by this honorable court.
Whatever, you make a mention before court number or approach it to registry.
Raised.
Yes, it can be. It will be listed before this court only. No issue. No issue.
Today itself, my lord.
No, today itself we cannot see you approach before a registry. That's
Did you?
all.
May
It
it please
will
your
be
lordship.
it will be nine. Oh. You made a good number. Equal. Yes.
May it please your lordship, with regard to item 22, lordship. In this matter, CD was called for, perhaps CD is not available today, and there is an interim also operating. Should be taken up in any other day, lordship.
Yes, for this 22, yes.
My lord, not CD, my lord. One report was called for, my lord, regarding registration of any. Petitioner is in interim, my lord.
We have not received the report.
Yes, report wanted.
Report not received. Should it be? Yes, when it can be.
My lord, on 25th.
Wait. We are listing it today. Interim be continued till next week. Mistake.
Report
25-3.
That be what can be.
25-3. Reported that. Yes.
Lordship, there is an interim order.
Yes, interim will continue.
Obliged, lordship.
So, I mention item 19, lordship. Perhaps CD is not there. Interim order is. This is not an interim, lordship. 119,
Yes,
19.
in that case, they will not receive my. Interim.
You are not interim.
Yes, lordship.
You are not on interim.
Interim order.
Interim.
It has interim order.
After the case, they are not received. Should remain.
After election,
27.
27th of April.
April.
27 for interim be continued.
Interim order may continue. Obliged.
May I please, your lordship? Lordship, with joint consent of both the parties, I beg to mention item number 8, my lord. My lord, matter will adjourn for the day and fixed it on 31st of March, my lord.
Well, I am appearing for the respondents here, both the respondents. Yes, yesterday, consent was taken, my lord, and it has been agreed that the matter can be taken up on 31st with an endeavor to dispose of at the admission stage. It's a proceeding matter of 145 CRPC proceeding.
You are seeking for 31st.
31st March.
31st of March.
March.
And the request and the request and consent for and with the consent of the other side. The matter is adjourned. The matter be accordingly listed on 31/3/2026 in admission.
There is an interim order in that may be continued.
Interim be continued. Listed.
Much obliged.
Lordship, I beg to mention item number 4, your lord.
Item number
4.
4.
Yes, your lordship, motion item. The engaged counsel could not turn up because of some difficulty, your lordship. I request that the matter may be passed over and listed anytime next week.
25th of this.
I am deeply.
May it please your lordship. Lordship, I beg to mention item number 16 of the daily list. Lordship, the case diary is not available. Lordship, kindly fix another date.
Petitioner is in interim.
You are interim.
Yes, your lordship.
Did not should remain.
My lord, 21st of April.
21 for interim be continued till next date.
Obliged, your lordship. Lordship, may I please lordship. Lordship, in item number 25, we have filed an affidavit that had not been tagged. That can be tagged.
25.
25.
You file an affidavit.
We have already filed earlier, lordship.
We are calling.
May I please, your lordship? Lordship, with the consent of the lordship, with the consent of the other side, I'd beg to mention item number 29. The matter will be fixed on 21st of April, lordship, after the due date. 29.
You are for the?
Lordship, I am for the respondent.
You are for the
I have
respondent.
taken the consent of the applicant.
Consent of the petitioner counsel for the. Sorry, respondent, wait for it. 21,
21st of April, Lord.
the request legit matter on 21st of April. Okay, validity.
May I please your lordship? I beg to mention item number 34. It is for hearing my senior is unwell. The date may be fixed after Bihu vacation.
Who is your counsel, senior counsel? Who is your
P. Kotoki.
engaged? P. Kotoki. You are MS?
And Kashyap.
Not MS and question. The current counsel for the submitted that this counsel, Mr. P. Kotoki is indisposed. And according to the important job, where fixed the matter accordingly after 2 weeks as on a date will fixed by the registry.
Your lordship, interim may be continued.
Criminal appeal.
IA has been disposed of. 17/4/24.
We don't have any I here.
It's already disposed of.
Then what to do? It is already disposed of.
But like
So we cannot continue any.
Lordship, I beg to mention item number 33. Due to a medical emergency, the conducting counsel's wife has been hospitalized, Lordship. So matter may kindly be
You are
adjourned.
for the appellant or for the respondent? You
Lordship,
are appealing for the appellant or for the respondent?
appellant, Lordship.
Appellant. You are PDAS?
PDAS, Lordship.
Her name is PDAS.
Lordship, give a date in next
And
week, Lordship.
appearing on behalf of the appellant submitted that due to some medical emergency and Wisconsin Mr. K. Borwell could not attend the court. Prayer. What you submitted? Fixed date you need.
Lordship?
Fixed date you need.
Yes, Lordship. In next week, Lordship.
No,
Any day, Lordship.
not at all. And paste it 23rd of April. Next week we don't have any dates.
Lordship, it is a POCSO matter and
Whatever,
punishment
what to
is
do?
5 years, Lordship.
Huh?
The petitioner has already been more than 3 years behind the bars, Lordship.
More than 3 years.
3 years, yes, Lordship.
Like, but you take it over.
Any day in next week, Lordship.
Next week we don't. 2nd of April.
May I please, your lordship? Lordship, I beg to mention item number 20, lordship. Lordship, CD is not received.
20.
Yes, lordship, 20. I'm on interim, lordship.
Yes, you are on entry.
I'm
Interim,
on
interim is there.
C did not receive. Should remind you. Yes, what happened?
On my lord, 20th of April, 24.
20.
20.
28th of April.
Yes.
Interim be continued in next date.
Obliged, lord.
May I plead your lordship? Lordship, I beg to mention item number 23.
20.
CD has not
Just
received
a second. 23.
23. CD
23 case diary not received, madam. Petitioner interim was
nine.
You are not on entry.
interim is not there.
City not received. You should remind. Yes, done.
Yes. 26.
Possibility of coming 26 is there.
Yes.
11.
26. You the not out of you. Part itu mau fix fix iya pikir kalau itu part pun mau boleh di kompetisi pikir part boleh tuh nih sama
Almost on item number 1. May I please, your lordship? Lordship, in this case, my lord, if the content of the FIR is presumed to be true, my lord, then also non-valuable offence is made out, my lord. Lordship may kindly peruse the FIR that is at page 9, annexure B, my lord. May I read, my lord? I beg to state that I am Abdul Ahad, son of Abdul Hasim, a resident of village so-and-so, PO Murajar Bazar district, Hujai, Assam.
With due respect, I inform you that 4-5 days ago, while I was going to Beluguri stone quarry with my dumper vehicle to bring stone as usual days, Kamaluddin, son of Khalil Moholdar, a resident of village Beluguri, Doboka, Hujai, Assam, has stopped my vehicle and has asked to take stone from him and pressurized me to take the stone with his asked price. And if I do not take stone from him, then I will have to give him rupees 5 lakhs. If I do not do this, then he will kill and bury me in this hill. He also pushed me and threatened me that he has relation with some high-handed person. Moreover, this type of words and incident is currently going viral on social media. So I getting a life threat, I came to the police station. My lord, in this case, my lord, the allegation is that the petitioner has asked the informant to purchase the stone from him on his asked price, my lord. It is his discretion whether he will purchase it or not, my lord. Moreover, he has another allegation is that if he does not purchase him, then he will have to pay. That is pay rupees 5 lakhs. That is not yet paid, my lord. No incident with the only incident is that if the content of the FIR is presumed to be true, my lord, that is threatening, criminal intimidation, my lord, which is a believable offense, my lord. And this FIR is also totally false, my lord, because, my lord, this Abdul Ahad has given his false father's name, false phone number, my lord, just in the eve of election, my lord, just to take a political revenge. I have stated in paragraph 6 of my petition, my lord. He has fired and put me behind the bar, my lord. Both the petitioners and the accused are the BJP worker, my lord. My lord, telling somebody to take purchase from me, that is not an offense, my lord. And even he has not given any rupee, 5 lakhs rupees to me.
You cannot force, no?
Three,
You cannot force anyone.
no, I cannot force, my lord. If it is also presumed to be true, that is a criminal intimidation, which is a believable offense, my lord. 351(3), my lord. And extortion is not done yet, my lord. And all these things, FIR is totally false, my lord. I have stated in paragraph 6, my lord. Kindly peruse the paragraph 6. 6 and 7. 7 is more reliable. As he has lost this FIR, just he is getting a life threat. This is the statement, my lord, in the FIR, my lord. Just to take a political revenge, he has put me behind the bar just in the eve of election, my lord. And 2 days back, the Eid is there also, my lord. My lord, kindly release the petition on regular bail, my lord. He is behind the bar for last 8 days, which the offense is there, not yet committed, my lord.
Yes, but
I do not understand what kind of political revenge, but my lord,
I have stated in
prima
paragraph
facie,
7.
my lord, from the FIR, it
No,
reflects that, my lord, he demanded an amount of rupees 5 lakh and also asked him to take, my lord, those stones only from him, my lord.
From-
These are the allegations, my lord. And in these allegations, my lord, what kind of political revenge only he knows. My lord.
no. Political, he is a BJP worker, my lord. And this asking somebody to purchase from me, my lord, that is not an offense, my lord. He has not given any rupees to me, my lord. Kindly peruse
see,
paragraph 7.
go by the record that
Yes, my lord.
think fair on extortion.
No, nothing, my lord.
That is not there.
Yes, yes, my lord.
Demand is there, obviously.
Demand is there, yes. Extortion not yet committed. My lord.
Yes, my lord.
Demand is there, my lord.
Threatening part
Yes,
is there.
threatening
demand
part is there, that is available, and
Available.
otherwise, my lord, only demand is there, that offense not yet committed, my lord, that is true.
Mr. Beach. Next, by submitted by Mr. Chan, that the present accused petitioner is not complete research office as well as India. Even if it is, even if the statement made in the FI is considered to be true, in that case also, there's no case made out, no non-bailable case is made out against the present petitioner. No extortion has been committed except the allegation. We further submitted that this entire case is closed by the informant with some political interaction before the ensuing coming election, before the coming election. However, the petitioner is in custody for 7 days, and hence, considering this aspect of the case, he may be released on Mr. Water Court identification will be submitted in this is the fact that no extortion has been committed, but he threatened the informant purchase goods from him within and also demanded rupees 5 lakhs. Accordingly, he submitted that city made considering the submission made by the statement made in the FIR and other aspects of the case. This court is of opinion that the further custodial interrogation in whose satisfaction this
CGM Pujay Shankarnagar madam.
CGM
Srimanta
possess-
Shankarnagar.
Okay.
Deeply obliged.
Matt Lee Lordship. In this case, my lord, the petitioner was arrested on 17/2/2026 by the my lord Lakhimpur my lord PS Lordship, and then he was on 18/2/2026. She was my lord taken by the my lord Palton Raja Police Station Police Lordship. Now she was my lord forwarded my lord without my lord proper service of my lord notice under section 48, 37, 36 Lordship. Now today is 28 days. First of all, kindly see Lordship. FIR is at page 12, Lordship. Without any, my lord, complaint from anybody, as regard deceiving, my lord, the police arrested 2 persons, my lord, thereafter subsequent, the petitioner from the 2 persons, my lord, allegedly fake gold, my lord, item was recovered, Lordship. Kindly see at page 14 is the FIR, Lordship. Lordship, now 2 persons, my lord, from whom the item was recovered, Lordship. Minhajul Islam, Hanif Ali. Now, Lordship, kindly see page 20, Lordship. Page 21 is the seizure list, Lordship, from the petitioner. What was recovered, Lordship? Just a mobile, Vivo mobile handset, Lordship. As per version of the my lord, arrested persons, 2 persons, Lordship, she was my lord taken from my lord Lakhimpur, Lordship. Now, kindly see notice under section 48, Lordship, at page 25, Lordship. '25, my lord, the photocopy is at page 26, Lordship. This was through WhatsApp, Lordship. This was on 18 February 3, 3:20 p.m. Lordship. 3:20 PM, my lord, she was forwarded, my lord, before the learned magistrate on the same day, lordship, 4 to 4:30 PM, lordship. Now, as per Mihir Rajesh Shah's judgment, lordship, he should have been, lordship, provided, my lord, before, prior to, my lord, at least prior to 2 hours, lordship. So this is, my lord, highly, now, this is WhatsApp, my lord, communication, lordship. That is not proper, lordship. My lord, the honorable court, my lord, in the, kindly see it is at page 31, this honorable court, lordship, has held. Observe that the WhatsApp. My lord, at page 32, this honorable court, my lord, from paragraph 4 to 4, 5, and 6, and 7, Kalisi, lordship.
Yes.
My lord, as per Mihir Rajesh Shah's judgment, lordship, it is clear, lordship.
My lord, page 15 is the FIR, my lord. Page 15 relevant portion is namely Srimati Onjima Khatun, the present petitioner, my lord, of Lakhimpur district allegedly provided the suspected gold pieces to the apprehended person for delivery to someone. She appears to be the mastermind behind. So from the FIR, it reveals that she is the mastermind, my lord. Although those fake golds were not recovered from the present possession of the present petitioner. And regarding, my lord, section 48, my lord, service communication of section 48 notice, my lord, that may be that for, my lord, in case of other accused person, section 48 notice is there, my lord. And regarding the present petitioner, that may be an, my lord, additional communication. Only CD will reveal whether, my lord, that 48 section 48 notice served to the present petitioner or not, my lord. I will have to go through the CD.
My lord, where is the, my lord, explanation in the forwarding report, lordship? Nothing is there. Kindly see page paragraph 52, very much clear, lordship. Of judgment, kindly see Mihir Rajesh Shah judgment, lordship. Paragraph 52.
For that, my lord, I will have to go through the record regarding section 48 notice.
No, if it is not served properly, lordship, and this honorable court has held.
How can I
If,
say at this
WhatsApp message, my lord. This is
WhatsApp
on that
message,
ground.
that may be
Bail
an
was granted. It was
additional- that may
stated.
be an additional communication, my lord.
Additional committee.
Maybe 48
My lord,
pieces also
additional
there.
committee or commission, that should be, my lord, apart from them, lordship. Communication to me, it should not, it may not be additional, lordship. 48 notification is, my lord, mandatory, lordship.
My lord, argument is that.
Kindly see, my lord, paragraph 52, lordship, of the judgment, lordship. 52. Lordship, may I read, lordship? We thus hold that in cases where the police are already in possession of documentary material furnishing a cogent basis for arrest, the written grounds of arrest
My
must
lord,
be
only
furnished.
record will reveal, my lord, whether section 48.
No,
notice served
prima
to the
facie,
present
at
petitioner or
this
not,
moment, my lord, prima facie, my lord, it should be my own reason. Well, must be furnished to the arrestee on his arrest. However, in exceptional circumstances such as offences against body or property committed in flagrante delicto, where informing the grounds of arrest in writing on arrest is rendered impractical, it shall be sufficient for the police officer or other person making the arrest to orally convey the same to the person at the time of arrest. Later, a written copy of grounds of arrest must be supplied to the arrested person within a reasonable time and in no event later than 2 hours prior to production of the arrestee before the magistrate for remand proceedings. The remand paper shall contain the grounds of arrest, and in case there is a delay in supply thereof is a note indicating a cause for it to be included for the information of the magistrate. Where is the explanation, lordship? Nothing is there, lordship. Now paragraph 56.
Mr. Ahmed, it is of 47.
Lordship.
It indeed 52 is entire 52 is of 47. Or you want to say 48? It is
My
of
ground of
47.
arrest 48, lordship.
No,
48,
it is
47.
47.
47 is also not served, lordship. 40, I have stated in the petition, lordship. 47 has not served in the court, my lord. It was, my lord, offered to me, lordship. To me and his
Your
relatives,
submission.
lordship. Nothing is there. 36, in the 36 notice, no relative signature is there, lordship.
One signature we have seen.
Sorry, lord.
Witness signature. One of the witness signature is available in the arrest memo also.
Arrest memo, 36 notice. She is not my relative, lordship. She is not a family member, lordship.
Now, your petitioner is from Lokhimpur,
Lokhimpur.
from where she has to be arrested because she is the main culprit in this case. And there, how police will get any relative
People were there, lordship.
in Paltan Bazar area. So there are some problems.
My lord,
So
in
that's why.
my lord,
Now,
in the 48
entire
notice.
52, entire 52, as you have submitted, is basically based for 47, not for 48.
My lord, what I am submitting, lordship, in the 48 notice, kindly see,
This is a WhatsApp communication. isn't
WhatsApp
it?
communication. That too, my lord. WhatsApp communication. Why it was communicated prior to, my lord, not prior to 2 hours, lordship. My lord, it was communicated, lordship. She was forwarded produced before the planet magistrate at 4 p.m., lordship. So then, my lord, not more than 2 hours, lordship. At least before more than 2 hours, it has been
Kind of
ought to have been, my
significance,
lord.
how
On
can
this ground, my
you
this honorable court, my lord, granted bail, lordship. In another cases,
Yes,
lordship.
My lord, here.
Anyway, lordship, today is, my lord, 28 days, lordship.
Next, my lord, rejection order, if any, of the trial court. From that rejection order, it, my lord.
have you annexed? No. You have
Not
not
an-
approached
not
the
an
trial
explore.
court.
Not an exploit. Anyway,
You have
lordship,
not
today is,
approached the trial court.
my lord, the trial court, lordship. My lord,
And the statement is also not there to the.
my lord, lordship, it is not. Yeah, lordship. Huh? It is ours, also. Huh? Sounds cool. Yeah, well, today's 28 days, and woman lordship having some problem, lordship medical documents, and my lord, release of bail. It does not mean that, my lord, the investigation will be hampered at this stage, lordship. Who accused from whom the, my lord, item was allegedly recovered, lordship. They have also been, my lord, interrogated, lordship. And, my lord, it is the settled position of law, my lord. Co-accused statement is not reliable, lordship. My lord, in case of conscience judgment, lordship, the Honorable Supreme Court has
Okay.
stated, my lord.
Okay. Heard Mr. M.H. Ahmed, the learned counsel for the petition. Also heard Mr. P. Bott, the learned additional PP, appearing on behalf of state. It is submitted by Mr. No, this is an application section so and so, information bit so and so. It is submitted by Mr. Ahmed, present petition is in custody since last 28 days. And nothing has been seized from his position. So on the basis of the statement made by the co-accused only, she got arrested from Lakhimpur. However, I got sufficient opportunity to interrogate him, keeping her in custody, keeping her in custody for last 28 days. Mr. Ahmed also raised the issue of non-communication of ground of arrest to her relative, family, or friends under Section 48 BNSS, and he submitted there is no sufficient compliance of Section 48 of BNSS. Mr. The relying on the decision of Apex Court in case of Mir Rajesh Shah, it has been submitted that that there is no communication of grounds of arrest to their family members before 2 hours from her production. He also submitted that considering this aspect of the case, the coordinate bench of this court also granted bail to accused persons considering non-compliance of Section 48 BNSS. Mr. Ahmed also submitted their decision of compliance of Section 6 BNSS while issuing the arrest memo to the petition. Accordingly, he submitted that due to non-compliance of the proper provision of law, as well as considering her length of detention already undergone the accused petition, he may be released. Next one. Mr. Bott done an additional paper submitted in this that that without perusal of the case diary, it is not in a position. He is not in a position to submit as to whether there was compliance of section 48 BNSS or as to whether before the WhatsApp communication was there any other communication to the to the accused to the family members of the accused petition under section 48 BNSS. More so, from her forwarding, it is seen that she is the main culprit of this case, who supplied all the fake gold items to the other accused persons for delivery to other persons. Mr. Bott accordingly insisted for the case. Next, but hearing this submission made by learned counsel and it reveals that there is a compliance of section 36 47 BNSS, and in 36 BNSS is also the signature of the witness is available, which is the available in the notice, available in the abstract. However, it is a fact that the 48 notice was issued through WhatsApp communication, but from the record it reveals that the accused petitioner belonged to Lakhimpur district, and she got arrested in the case under the Portland Bazaar police station. So it may not be possible for the police personnel to serve notice under section 48 BNSS instant to her relative, and hence for onward transmission the notice may be sent through WhatsApp, but without the perusal of the case diary. It's not proper to say anything in regards to the communication of 48 notice to the petitioner. In view of this, let the CD be called for. When it can.
My lord. 1st of April.
1st of April. We're calling for
My lord, 60 days offense. Today is lordship. Today is my lord 19 lordship, 28
Yes,
days.
that's why we are listing it on first of.
Oh my lordship.
আমার বিয়ের রাতে আমার
May I please you, Lordship?
yes.
Lordship, the FIR is at page 25, Lordship. Where the FIR has been lost against total named 7 person and some unknown person, some others, Lordship. Here, Lordship, we have 3 petitioner preferred, Lordship. The accused number 1, 2, and 7, Lordship. May I read, Lordship, the FIR, Lordship? Most respectfully begs to state that the name of my younger brother is Abdul Quddus, who is aged about 42 years. He earns his livelihood by operating a motor drive boat in the river on 31/1/2026 at about 11:30 a.m. while my younger brother was returning home from Suntoli River Bank Ghat as per the instruction of accused number 1. Who is petitioner number 1 here, Lordship. As per the instruction of the accused number 1, the other accused persons have blocked him on the Morisakandi route. Accused number 2 struck him on the head with a bamboo stick with intention of killing him, causing a head injury and bleeding, and caused serious injury. The remaining accused persons also assaulted him with sticks on different parts of his body. As a result, he fell down on the ground and caused serious injuries. My brother's 150 Pulsar bike bearing registration number so-and-so was also broken and damaged badly by the accused persons. When my brother started shouting for help, the nearby neighbors came and rescued him from being killed. He was immediately taken to Suntoli CHE. However, considering the seriousness of injuries, the doctor referred him to GMC's Gauhati for better treatment. As my brother's condition was critical and as such, he was admitted to ICU. As present, he is still under treatment. The delay is launching FIR as we were busy in medical treatment of the brother. Rashid, the allegations are serious, though. The background behind the case is I have annexed some documents that what happening in that area, some illegal excavation of soil and illegal excavation of soil is happening. And the area is riverine area. Some village is there where one village Pampara, where the illegal excavation is been doing. So some people are doing that, and the people of the entire 3-4 villages are opposing that excavation here. So the complainant, the petitioner number 1, he is the government Gabura of village Pampara. Being the mouthpiece of that village, people of that village, he lost complaint also before the circle officer and OC. And the secondly, the Ansolik Panchayat member also lost complaint before DC, circle officer, everyone. The local MLA has also lost complaint regarding that illegal excavation. Because if the excavation happen, your lordship, in the coming monsoon season, there will be devastating erosion, your lordship. That's why the people are opposing. And the one on that day, your lordship, what happened, lordship, the public at locality opposed for excavation, and a quarrel took place. Some people has beaten that the injured person, and the FIR has been named against the accused person because we have been opposing since initial stage. Because in the on December 29, the petitioner number 1, being the Gabura, lost the complaint before the OC and circle officer. So the entire the incident happened between the public and the people involved in the excavation. The local MLA has also wrote before the DC. So I have been why implicated, your lordship, because I have been opposing, but I was not involved. I was the guy. I am the Gavura, local Gavura, the Gavura of that village, government Gavura. How I will involve in this this incident of grievous hard loss? I am being the accused number, the petitioner number 1, and the allegation is that as per my instruction, the other accused person has committed the offense, and the FIR named 7 person and others. That means, lordship, the people of the entire area were involved. Because of that, they're threatening of because coming the monsoon season. So the accused number 1, being the Gaugura, he is just trying to protect the people. He is not involved in this case. So this FIR has been lost. I admit that their allegations are serious, but we have been implicated because of that. We are protesting that and there is communication of the circle officer also, and the report of the circle officer and the ADC also, that there are excavation is going on, and that's why I'm lost faith. At this stage, I'm paying for interim protection.
Till now, admitted in the ICU, treatment is going on. And
admit-
regarding accused number 2, there is specific allegation that accused number 2 struck him on the head with a bamboo
Yeah.
stick with intention of killing him. And accused number 1,
I'm the Gavura of that village. That's why I have to protest. I have to protect the people of that area, and the area is riverine area, you Lord. So I have been implicated. The accused number 1 and at least act number 1 and petition number 1 and 3, they have been implicated because they are protesting. Accused number against the petitioner number 2, there is a specific allegation. Accused number 2, I admit that. So I'm saying at least petitioner number 1 and 3 should some interim protection may be given. Otherwise, I will not space for interim protection at this stage. And the communication shows clearly, Lordship, and the Lordship may kindly see
You are
the.
You are Mr.
I'm J. Abbas, Lordship.
A. Abbas.
J. Abbas, Lordship. My name is not shown in the, but I have filed Ukaratnama. Probably
Your
there is.
voice there.
Yes, but in the cause list, my name is not shown.
Third, Mr. J. Abbas. Second, report. Submitted by Mr. Abbas. No, there was something which was going in the state locality, and for which the question of being the product had also made report DC and chat members. The local area also made complaint before the DC. These petitioners are raising their voice against the excavation and the from and let's say for which the some villages had a forest which it's but on that grudge only the FR has the petition number one, the had only tried to stop the illegal excavation to that extent. He, along with the other petition, moved some representation before the DC of the petitions treaty and willing to extend petition ordinance. There some important there are serious we still admitted with the IC. In that effort, there is specific allegation against the accused petitioner two who hit a victim with a weapon, for which is report for recording of there is a privilege of interim restraint to represent for one and three. However, the prayer for interim protection for the accused petition number 2 is not considered. Okay, 1 and 3 will be under interim protection. We are calling for the
I'm deeply
case
obliged.
directly along with the medical.
Obliged, sir.
6th of April,
6th of
6.
Can I do 8th, Lordship?
Yes.
8th, Lordship. Deeply obliged.
May I please, your Lordship? Here in the petition number 1 is the son of the petition number 2, and the petition number 2, he is a government servant, your Lordship. I have annexed the identity card of the petition number 1. This 14-year Lordship, kindly have a look. This 14-year Lordship. The informant, he is the what? She's
yes. Informant.
She is the wife of the petition number 1, your Lordship. And
Wife.
wife of the petition number 1, your Lordship. And she has stated here in that one, 22 to 2026, the informant was beaten by the petition number 1 as per instigation of the petition number 2, your Lordship. And on that day at night, the petition number 2 entered into the house of the informant, and she was assaulted, and thereafter she was forcefully committed rape by the petition number 2. And who is the father-in-law of the informant, your Lordship? This is the allegation, your Lordship. But in fact, your Lordship, there was dispute in between the husband and wife. I mean the petition number 1 and the informant, your Lordship. And the informant went to her parent house, and subsequently he returned back to the petition number 2, and again she started happy conjugal life with the petition number 1. And page 16, your Lordship, kindly see. And the page 16, your Lordship, kindly have a look. This is an affidavit shown by the informant, your Lordship. Page 16.
Yes, what's he say?
Herein she has said that out of misunderstanding, your Lordship, that affair was lost, and presently she has amicably settled it. But what I got instruction is that, your Lordship, she is presently living along with the petition number 1, your Lordship. And there is at present no dispute, your Lordship. And in fact, herein the dispute was in between the petition number 1 and the informant. with regard to their matrimonial relation, there was some misunderstanding, and the informant left her matrimonial and stayed in her parent house, Your Lordship. But the allegation of rape is made against the father-in-law, Your Lordship, who is a government servant, Your Lordship. And they are presently, Your Lordship, performing heavy conjugal life, Your Lordship. And dispute has already been resorted.
The FIR, my lord, allegation of rape is against, my lord, petitioner number 2, that is father-in-law, my lord. And my lord, also the accused number 1 has brutally assaulted, my lord, on the same day, my lord. And
On the
regarding
same day, she
regarding
was
the affidavit filed by the my lord, informant, my lord, under what circumstances she filed this affidavit, my lord? So she will have to disclose before the IO, my lord.
And one copy, as per my instruction, Your Lordship, one copy of this affidavit has already been served to the IO. And 122 to 2026, he was assaulted by
Only
husband, and on that day, Your Lordship, at night, she was committed rape by the
Only
father-in-law.
submitting the affidavit before the IO, my lord, will not do. She will have to appear before the IO and record his statement. Why she has, my lord, deposed this affidavit.
And therefore, only, Your Lordship, I am praying, Your Lordship, protect me, Your Lordship, and so that we may give our statement.
Report United Nations. The and the innocent. However, it is the fact that there was a matrimonial dispute between the informant, who is the wife, informant that they accused petition number 1, who is the husband of the matter itself. Now she is staying with the accuser. She closed the FIR on the some Wisconsin. Then that she already sworn in, which has been annexed. One copy of the affidavit is also produced for the accordingly structured submitted that some interim report and that the petition, the informant brought the allegation of assault as well as the rape against the accused. Okay, you'll be under interim. Yes, what about when it
On, my lord, 23rd of April, my lord.
Right.
Wait, please, Your Lordship. Once a pre-year as bail, my lord, Your Lordship will find the FIR at page 8, my lord. May I read, my lord?
Yes.
Respectfully begs to state that the above accused, Tabibur Rahman, and that accused number 1, is my elder brother, and the rest of the accused are my nephews and sister-in-law, and Nawab Ali is giving bad advice to Tabibur Rahman. There has been a long dispute and disagreement with the accused for the division of our paternal property. Occasionally, the accused threatened to abuse and beat us. The accused were found to dump soil with a tractor on the land in my possession on so and so. And on 15/1/26 at around 6:30 p.m., my son Rahul Amin went to the place where the accused were dumping the soil with a tractor, and my son told them, first you resolve the matter, then you dump the soil. Then the accused, Tabibur Rahman, started beating my son and hit him on the head with a hoe, my lord, from behind to kill him, and then started bleeding from his head, and he fell unconscious on the ground. Then Akash Ali and Hasmat Ali arrived at the place of occurrence and saved my son from the clutches of the accused. Later on, with the help of these people, we took the boy to the Bompeta Medical College and admitted him to the medical. The complaint was delayed as the boy was busy in the medical treatment. Well, it is a family dispute over a plot of land, my lord. I have narrated the fact, my lord, at page, my lord, 4, paragraph 5, my lord. That the petition, page 4, paragraph 5, that the petitioner begs to state that he is a cultivator by his profession, and the fact is that when the complainant and his family member forcefully entered the petitioner's land, the present petitioner and his family member obstructed the complainant's side, and there was a push between them. Admittedly, there is a dispute, my lord, and the FIR has been filed, but it is between the family members. And the present petitioner, my lord, he is aged about 60 years, my lord. Sorry, my lord, 68 years. My lord.
That as per the FIR, he is the main.
Yes, yes. Some difference between the family members, my lord. Land dispute.
Yes.
Only when Tabibur Rahman started beating my son and hit him on the head. The treatment is still going on. Only when the CD and injury report will reveal the involvement of the present accused person.
Between the family, my lord. That's the,
Obviously,
let the
the land dispute was
land
going.
dispute.
Is that understand with and admittedly there was a land family dispute between the informal side and the who were the there was some quarrel between and push that yeah. That is the that is the therefore that the respective against brought against the present assaulted baby for the previous case. Previous was previous case on the about state for the think it's a okay, you'll be under interim.
Fine, I'm obliged.
On 23rd of April.
I'm obliged.
May I please ask?
Yes.
So this matter already proceeded third to the co-case. Case number 13 is the FIR. This is a 3 years bail. Co-case lordship already granted bail, my lord. This of the FIR is the lordship. There is a between my lord quarrel between two group, my lord, two political group lordship. Case number 13 is the FIR. My name is there lordship in the admittedly. Lordship has fixed the connected matter on 26 March. Quarrel between two political groups. Yours of that political group. Paragraph 7 is the three. Paragraph 7 of my petition, my lord. What is happened actually on that day, lordship?
Present petitioner is accused number 1.
Lordship. This is the MLI, let me quickly, my lord. Lordship has granted interim protection, lordship. This is the order. I also annex in the petition. Lordship has fixed on 26 for CDL injury report, lordship. Paragraph 7 is the what is the actual fact, lordship. My lord, considering the upcoming it on 21. So I pay for only 7 days interim protection. Since my lord already CD is fixed on 26. Lord. Work is already granted bill. I have annex also. Lordship has fixed in 26. And one my lord.
He is the FINM accuser. Your
Yes,
petitioner
yes.
is an
Lordship,
FINM
FINM
number
accused, my
one.
lord, case number 23 also is finally similar. Case number 23 also is there, lordship.
In paragraph 4 of the FIR, victim recognized, my lord, identified the present.
No, I'm not disputed, lordship. Only for 7 days, my lord, on 21, my lord, it is coming, lordship. Yeah, therefore, lordship. If my lord, something found, my lord, my bail pair may be. There is no, immediately, lordship has observed that this is my quarrel between two political groups, lordship. They also beaten, we also beaten, lordship. My vehicle is at present, my lord, police station, lordship. So he is willing to cooperate with the investigation, lordship. If anything found, lordship, lordship may take on 26, only for 10 days. That to considering the my lord coming Eid on 21st. Therefore, I'm not denied disputed, lordship. Immediately, this is my lord quarrel between two political groups. On that time, there is a meeting in the Hailakandi. My brother is a ticket expand from the Congress party. So there, just to therefore, I have stated in the paragraph 7. Lordship.
You are from Hailakandi?
No, my brother will contest election from Hailakandi, lordship. The FI, this is stated, my brother. Jubair Alam, President of Indian Congress. Only for 7 days, lordship, if found, my lord, I may be rejected because already granted bail for quota CD and medical report. And also considering the upcoming Eid, therefore, admittedly, there is a quarrel, my lord. They have also beaten, we also beaten my vehicle in the at present police station.
But under which 118 is also there?
No, sir, no, sir. This is there. Only for these days, lordship. Only for these days. If anything found, lordship, I may be rejected, lord.
Yes, what?
Video footage USB drive is also there, my lord, and he is accused number 1. Only
CL
because
number
how
one.
he can take it a grounded political rivalry.
No.
Brutally assaulted, my lord.
No, my lord. In the FI, it is stated, my lord. I beg to say that I am the president of
He may be a president of whatever political party.
Yuva Morcha. Informant is that Bharatiya Janata Yuva Party.
He may be a political leader of any
Congress,
party.
we are not on that.
No.
There is a quarrel.
Quarrel.
There is a political.
Yeah, lordship.
That is the.
And my name is it's CL number 1,
The
lordship.
fact is that my lord, he assaulted brutally. My lord.
Considering the other.
How many injured are there?
Only one person.
That person. Repeating it. So that since my lord.
Should be go with it and it comes to the petition. Should be about an application submitted by Mr. Gauhati, the petitioner in that. It is the fact that there was a clash between two groups, clash between two groups for only for political rivalry, and the petitioners is also one of the ticket expired from Hailakandi Legislative Assembly in the forthcoming assembly election. The other co-accused persons have also did interim protection considering the case petition as input. You may also be provided with some interim protection. He is ready and willing to extend his cooperation in further investigation of this case. Is not declared some. Thank you for an will be subject. He is the FI named accused who brutally assaulted the victim, sustained grievous injury on his person. If further submitted, there may be political rivalry or group clashes between the parties. Name of the present petitioner is specifically mentioned in the FI who assaulted the victim. Accordingly, he insisted during this submission made by vis-a-vis considering the same with the other. Is code it of opinion that an interim report will 2060 is the
Lordship, 26 for CDN medical report.
2060.
Lordship granted. Deeply obliged.
Can my lord case the scan copy of
TCR is not.
scan copy of TCR not received?
It's received, Mr. Bhattakur, we have received.
No, my lord.
Oh, it's caused this, it is not written in fact,
Yes.
but we have already received.
Then I will have to go through it.
When it can be fixed.
That's one here.
Today may not be possible. We have a
Oh,
reference.
yes. Any other date, my lord?
Your petitioner is behind the bar since when? Oh, it's a charge sheeted case.
Charge sheeted case, ma'am.
What is the stage of the case? Can you tell us? The other side. Can you tell us what is the stage of the case?
Sorry, Your Lordship.
Before the trial court, what is the stage of the case?
Sorry, Your Lordship. I just have limited instruction to the senior about this case.
Commercial quantity, my lord, NDP.
Yes. No. That.
Oh, yes, stage, my lord. Stage is, my lord, from the petition, my lord. From the court.
When it was going to be like this part of Amilu, reject will have a great expected to do. No, I irresistible. And I either rock, I did a comment, take it by the family for it. It is reject for a pellet. Are we going to available for the pending cards? The pending cards. We are listing it for appropriate bench.
Yes.
Special forms which we are not taking this special
Yes.
bench.
Yes, ma'am. After 2 weeks before any other.
So let it a date be fixed because he is in custody.
Yes.
So the petition has already been received. However, the ST is hereby directed the ST matter in appropriate bench. It is 25th, 25th. Well, listing it on 25th before appropriate bench.
Your Lordship, if it's possible, 1st or 2nd of April.
1st of 2nd of. Okay, then 1st of April.
Much obliged, sir.
Level, my lord, case diary not received in this case.
Lordship, I have the instruction, Lordship, that the charge sheet has been submitted in this matter, Lordship.
Submitted.
Yes, Lordship. In the
Can you tell
meantime,
us
after
any-
filing of this application, it was submitted. And he is behind bar for 47 days, Lordship.
Charge sheet number was.
Nah, Aji Rajipa compaiso actually,
Then, well, I will get the instruction, well, after some time. I will get the number.
Lordship. Number to power cards upon it?
Okay, then we are listing after some time.
After some time.
Yes, 12.
12 case diary.
Yes, what you want.
Rajwali, yesterday's, my lord, dispute PSK 72-26. Your lordship has granted bail to one purchaser of that. That section was not added because of that, my lord.
Oh, acha, acha. No, but he is the Rajwali.
He is the Rajwali, he is the main snatcher, man.
Oh, he is this chain snatcher.
Yes.
Since when you were in custody?
Well, Lordship, from 17 to today is 31 days left. And stolen articles are already been recovered, Lordship.
He seems to be, well, he is habitual, man. Okay.
Yeah.
Chalo, koriye.
But yeah, Lordship, finally considering the detention period, Lordship, that petitioner may be allowed to go on bail, Lordship.
These are serious offences, my lord. Chain snatching, my lord. My lord, only length of
31
yeah,
days.
my lord,
Yes,
he is habitual. He is also, my lord, the other cases also pending against the present accused person. He appeared in 2 other cases, Jalukbari. Though, my lord,
Those are fixed on last part of March, Lordship.
we-
Please.
20th of March, my lord, other 2 cases fixed.
20.
Lordship, considering
He is a habitual, most probably, but here mostly chain has already been
recovered, Lordship.
On being leaded by him, my lord. My lord, chain recovered, but exactly, my lord, the whether this the present the chain which was already recovered on being leaded by the present accused person from jewelry shop of one Moinul Haq. My lord, yesterday Moinul Haq was granted bail by your lordship, my lord. Whether, my lord, exactly the, my lord, owner of that gold chain, my lord, I have not found anything that he has identified that this is my chain which was snatched by the present accused. That chain was not yet identified. Because during, my lord, investigation, while from the other accused persons from that jewelry shop, my lord, along with the some of the many other, my lord, stolen articles were recovered from them, my lord, during during search in respect to the present case, my lord. Till now, the informant of the present case has not identified that this is my gold chain, my lord. Regarding that aspect, my lord, I have not found anything in CDM.
Then what to do? What to say? Because
Regarding-
returning the case diary updated will also, I don't think it will serve your purpose.
Yes.
I don't know, may or may not be. What is the case? I cannot see. Or whether the chain is the chain which has been stolen, you are not in a position to say.
Yes.
There's no note of the IO.
Gold chains, my lord, silver chain, and many other items also recovered. But my lord,
those were recovered.
this is the exactly, my lord, chain which is related to the present case. That was, my lord, not identified by the owner of the.
that is the part of the investigation, Lordship. Already 3 numbers of stolen gold chain has been recovered, Lordship. Page number 15, Lordship. Forwarding.
And that is we have already seen.
Yes, Lord.
After some time, my lord,
Informant will identify the same,
I will
Lordship. But
get that instruction
considering
from
the
the IO.
detention period, Lordship, I may be allowed.
Because second half most probably only 1 hour the court will say.
Yes, yes. Immediately after some time, I will
For
get
some
that.
time?
Yes.
Yes, what is 13?
13, my lord, case they received, my
You have
lord.
received the case diary.
On that day, my lord, your lord.
Yes, on that day we have heard Mr. Bora at length.
Yes,
He
yes.
submitted on the basically on some law points also.
Yes, yes.
And yes, Mr. Bora, you have anything to submit? Other
No,
your submission.
No,
I have
nothing,
already
nothing.
recorded
Let
in
him,
last
let him, what is the material they have
Yes.
collected? As far as my instruction, these are the material which I have already placed
Yes.
before your lordship.
Yes, my lord.
This is the only material which has been seized
That is
from there.
2 leaflets or
2 leaflets, my lord, search sheet.
yes,
My lord,
Mr.
case they received, my lord. Investigation is still going on. Earlier, my lord, 2 rejection order of the trial court is also in the case diary, my lord.
They have also submitted.
And regarding those leaflets, my lord, on that day also I pointed out regarding those leaflets, my lord, initially recovered, my lord, from that vehicle 331 numbers of leaflet. Thereafter, again from the plate, my lord, plate number C202. Later on 250, my lord, other bundles were recovered, and the statement of the accused persons also recorded. During their statement, all the accused person trying to shift the burden to entitled to one Joinal Abedin, who is also one of the petitioner, that is petitioner number 3. Well, I will hand over the CDA to your lordship, Your lordship can.
No, the point is, 3 points were raised on that day by Mr. Gauhati for approving these sections. Especially earlier 124 and
Yes,
152 basically.
Yes.
And 196 and 197. To that regard, do you have any submission? Otherwise,
That aspect, my lord, from the contents of the, my lord, that leaflet, my lord, from the contents of the FIR, my lord, prima facie that section, and regarding, my lord, whether, my lord, to discuss in detail, prima facie, because investigation is going on. FIR laws only on, my lord, recent 8-3, my lord, 8/3/26, and thereafter investigation is going on, and during investigation, those leaflets were recovered. And those recovered contains that, my lord, what are the, my lord, contents of that leaflet? Already your lordship has gone through it. And from the prima facie, from those contents, my lord, it reflects that those are not mere, my lord, political criticism, or that which will ultimately, my lord, attract section 152 or section 1 prima facie attracts, my lord. Otherwise, in detailed discussion regarding, my lord, all other materials and those, my lord, contents of that leaflet, my lord, directly, my lord, which influence the election, my lord, process of election, and election is forthcoming, my lord, or considering that aspect on that day I pointed out to your lordship. And regarding, my lord, in detailed discussion regarding whether in fact, my lord, 152, my lord, attracted or not, my lord, all those, my lord, because investigation at the initial stage. Otherwise, at the time of framing charge, my lord, those, my lord, materials will be discussed, my lord, in detail, my lord. But prima facie, from the contents of the FIR and from the contents of that leaflet, my lord, prima facie, my submission is that those sections are attracted, my lord, at this point of time. So regarding those, my lord, I would like to submit before your lordship. I have flag marked the to rejection order of the trial court.
We are not on appeal, my lord. Lordship is not bound
Yes,
by
yes.
the trial court order. We are not appeal.
Yes.
Sitting on appeal, I am just placing. I have already placed on the last occasion.
And regarding, my lord, section 48 notice, my lord, I have pointed out from the one of the trial court order. I have.
Bora is not insisting on 48.
I have 48, yes. Then
It's okay, 48 is there.
Yes.
But these 3 sections, but yeah.
48, my lord, it was not given to, it is given to the one person, to all the members, all the accused person, my lord. They are not connected, and we have not authorized the person. There is no written authority by us, my lord, to accept the notices.
Assume.
It is only assumed. There is no authority, because there has to be some authority from us, my lord.
Okay.
He is not the nominated person in writing by us. That is my submission. On the basis of the instruction from the client. From my client, he is not known to us.
Regarding that, my lord, Abdul
So, my lord, other than this leaflet, my lord, whatever material is there, for him, this is the material which shows that this is the, my lord, the attract, my lord, sedition, my lord. This is the material of sedition, my lord. So nothing apart from this, my lord, has been seized. So, my lord, already material been seized. That is admitted by him, my lord. All the materials they have seized, my lord. Their purpose is done. And as far as, my lord, I am concerned, my lord, for me, my lord, it cannot be a sedition, material for sedition. And the irony of this, the leaflet is that, I'm just adding, my lord, that the person who has prepared, who has author of this leaflet, he has yesterday, he was welcomed by the person against whom this leaflet has been prepared.
These are politics.
And all these small people, for their own, my lord, survival existence, were working, they are inside the custody. And the person who has the author of these 2 leaflets, you can see in the when it was made public in the press meet, he was the person who's the author of these 2 leaflets. Now he was welcome by the person. The irony is that by the person against whom he is written. And this is, and the public prosecutor is defending, and he is saying that means the person against whom it is written, he has welcomed a person, author. An author is who is, my lord? He is as per he is the 152. Who is he? He is the person who is against the country, sovereignty of the country. It's a person who is against the sovereignty of the country. He has been welcomed by the victim, so-called victim, my lord. That's all, my lord.
My lord, in this regard, I would like to point out to your lordship one thing, my lord. Till now, who is the publisher, printer, and
This is all in the media.
leaflet, my lord, that is not there in the leaflet, my lord. So, my
Who's
lord,
that? It's
regarding
not on the leaflet.
it not
What is
only
saying is
Whether your CD
leaflet
will
with
defective.
media.
Yes.
That is his submission. and
Yes.
It was published, already been published.
So, my lord, regarding that aspect, source, my lord, who is the printer?
That is already there. Everybody knows it.
Regarding that aspect, my lord,
Expect, Mr. Counsel, except you, everybody knows it. That's the irony.
my lord,
You defend it for your purpose of your
I can
whatever.
only go by the record, my lord.
You are not going by the record. That's the irony of this country.
Yes, I am going by the record, my lord. What is there? I pointed out.
If you
to-
go in by the record, you place the CD. You read the CD. Who has so many days? Who has published it? When it was published?
How can I say, my lord?
When it was from the CD? Why don't you say when it was published?
Investigation is going on regarding
No,
that.
we know investigation is going on. For all the cases, investigation goes on, and you'll put the behind the bar.
This is the
You will
necessary
you will not say anything against the publisher. You will not say anything against the when it was made public. You see, these are the material. It was placed in the press pit, my lord. 7 days back. That's all, my lord.
My lord, regarding Abdul Motin, my lord.
Oh,
My lord, I would like to point out one thing, my lord, regarding Abdul Motin, my lord. He has filed, my lord, who has received the nominated by the accused persons for receipt of the, my lord, section 14. He has filed bail application on behalf of all the accused persons.
Oh, he is the person.
He is the person. He has filed bail application on behalf of all the accused persons.
The nominator, he is not the nominator. Our case is filing of the bail application is a different issue. First of all, 2 hours before, you have to give a notice. He may be a lawyer. Lawyer can file an, but whether these notices is given to the person designated by the accused 2 hours before the arrest, my lord. It has to be. That is the mandate of the Supreme Court. Subsequently, who has appeared, I can appear for all the accused in the court. That's not the mandate of the 48. 48 is 2 hours prior to the arrest, my lord. You have to serve the notice to the designated person by the accused. Maybe subsequently their lawyer, somebody may have designated, my lord, within 1 hour or within half an hour also. That is not sufficient for the 48. 48, 2 hours prior. That is the Supreme Court judgment, my lord. That is, both are separate.
Very formally. The point of- Yeah. That the investigation is still under and large numbers of good quantity of leaflets were seized during investigation efforts, and prima facie from those leaflets that there is a prima facie case against this section in which the case has been registered under the case taken only Mr. Boras let some আবার একটু লিখে দিব Mr. Boras that the 48 notice which was issued to the present petitioners are not the person who has been authorized or nominated by the accused persons to receive the notice under section 48 PNSS for all for their behalf. Neither he is the family member or relative of the accused petitioner, nor if he was authorized. In that context, Mr. Boraku, in an additional PP, submitted that though they stated that he is not the authorized person, but the petitions, the present bail application has been filed by the said person, whose his name was what?
Abdul Motin.
Abdul Motin, who received the notice of under section 48 PNSS on behalf. Actually, this entire dictation was typed by one of my the Rupam, he typed it. So more or less your submission will record same submission. And the order is accordingly your granted bill. You want any interim bill may be granted. If you have any condition. Otherwise, no issue of
Your lordship may also dispose it of
dispose
my,
of case. Interim bill or billing.
but
With
with a direction there to comply with my lord,
Yes, yes, obviously, the direction will be there. It has to be
cooperate with the
Kamru.
investigation.
CGM Kamru,
CGM.
CGM Kamru. Otherwise, you bill.
God bless.
Mungkin আপনি লিখিয়ে ফেললে মুখে একটা মারি দিব তারপর রূপমে মুখে না সেটা তো অল্প এক সেকেন্ড আর বাকি লিখি লিখি my best. Yes, what is 14? That's
Your lordship. Here, my FIR at page 13. my lord.
received here is diary.
My lord, IO has prayed for some time, my lord, to produce the case diary. IO has submitted a detailed, my lord.
What is problem?
Yes, your lordship.
Report to DG. Otherwise, my lord, the petitioner before your lordship is not named in the FIR, my lord. That they have submitted, my lord, some
Yeah.
SIM cards were issued by two stores, my lord, Xerox store and Ponky store. Not by the petitioner before your lordship. He was an employee of Vodafone, my lord. And he has no role in, my lord, verifying those documents before, my lord.
Mr. Abdullah, it is it's okay.
Lordship.
But the IO prayed for some time. There are some reasons for which the report has been furnished by the IO at the state. It's not so simple case that you are not to be authorized the verification and all. There are some materials. Oh, I don't know whether materials are there or not because
But there is, prima facie, there is no allegation against him, my lord, in the FIR. And my lord, the allegation is against Xerox store and Ponky store, my lord. And my lord,
you were working there in
Vodafone.
An employee of the Vodafone.
Admittedly, employee of a Vodafone, my lord. Vodafone, my lord. And he petitioner has a 2 year
Your
old.
lordship may fix any sort date, my lord. I will try to wait it.
Petitioner has a baby, my lord, 2 years old, my lord. I leave it to your lordship, my lord.
The IO has
otherwise
considered.
I can understand he is an employee of Vodafone, but his connection I don't know how.
Yes, ma'am.
From the forwarding report
yes,
also.
what is the forwarding report says? How he is connected?
Forwarding report general.
My lord, huge quantity of my lord.
But nothing against him,
SIM
my lord.
cards recovered from
And
the,
moreover, my lord, 35(3) notice prior to arrest was not served upon him.
that reason, my lord.
The reason has been given, but
stated,
not
my
served
lord, in
upon
detail,
him.
my lord, in
Where
the
is the
full
forwarding?
forwarding report is at my lord relevant page 17.
17, my
On
lord.
page 17, my lord. Grounds of arrest is at page 18, my lord.
There is no specific my lord, materials against the present petitioner, my lord.
Along with you, you are Mr. Your petitioner's name?
Moinul Haq,
Moinul Haq. Acha, 4, number 5, na?
number 5, my lord.
So from you, what is recovered?
No, nothing, my lord. No, nothing was recovered from me. It is, my lord, admittedly,
He supplied all those SIM cards.
my lord, I cannot directly supply. If if the company, they will have, the company sends me, my lord, I'm just an employee, my lord. My lord, my identity card I have annexed, my lord. Page 20, my lord. Is my identity card. So, my lordship, may I pray, my lord, the lordship may grant interim, my lord, and call for the case diary, my lord. If there is something, my lord, lordship may recall my interim order, my lord.
The two stores are Herox store and Monkey store.
Monkey store, my lord. Admittedly, SIMs were distributed by those two stores.
But obviously, there has to be link with the Vodafone employees, otherwise,
Yes, otherwise.
large numbers of SIMs can
SIM
be.
cards, ma'am.
But,
Because,
my lord,
because
some-
if we go for apply for a SIM,
Yes,
many things are there.
Yes, my lord.
Verifications are there and
Yes,
all.
yes, my lord.
everything is
So,
there.
no, nowadays
Aadhaar
it is
card,
very,
PAN card,
this
everything is
document, that
required.
document, they ask, my lord.
And
Not with
some SIM
documents
cards,
are
my lord, directly linked to my lord committing financial fraud. My lord. Regarding that aspect, also there is mention in the FIR.
But my lord, financial, what financial fraud, it has not been mentioned. But regarding that financial fraud, my lord, I am not involved, my lord.
Because through these SIM cards are the main, my lord, through which all these offences, my lord, committed, my lord. Initially,
Like he is also related with those offenses through.
No, my lord. No, I am not related with those
maybe
offenses.
there without having
My lord,
any link,
no, my
my
lord,
lord, without having large numbers of SIM card to particular stores, my lord, thereafter, my lord, without knowledge and my lord, without
Yes, obviously some suspected SIM through suspected SIM cards through financial frauds were there.
yes. They may not be, my lord, directly involved in committing, but they are supplying of those SIM cards, my lord.
My lord, if they will have
They
the
may
company
receive, my lord,
sends
huge
me, my
amount
lord.
of commission.
I am, my lord, I am not the, I am a simple employee, my lord. Lordship may see, my lord, not a big.
Simple employee, but without the help of these employees, my lord, this type of offences could not have been committed, my lord.
But it's just report and in addition everyone. City not receive but submitted for the IO paid more time for furnishing the city as the case is still under investigation. One report has been submitted by the IO stating some details about the about in this case. Expert Mr. Abdullah regarding council submitted that is he is a Vodafone employee and some SIM cards were supplied from their company to say two stores, namely one Xerox store and one County store. And then his involvement is he is no way involved. He further submitted that unless the company authorizes him to deliver the SIM cards to any shops, he cannot deliver the SIM cards. And being on employee, considering the demand of those stores, he simply supply those SIM cards to those stores. But if any financial fraud has been committed by using those SIM cards, is not known to him, nor he is involved in such activities. However, the present petition is in custody since 20 years,
8 months.
8 12, and the which as updated that he will extend his cooperation in further investigation. Confident submission made by land petition hereby over interim bid for issuance and CDB To whose satisfaction it has to
As a CGM Kamrup Metro.
be CDM. Interim.
Date.
22nd of April.
Obliged, my lord.
With condition that
I'm so grateful, my lord. Obliged, my lord.
yes, what is the position of 15?
Check here. Even Lordship, may I place a document, Lordship, although it is clear off? Even
Yeah,
yes.
matter earlier came up on, my lord, day before yesterday, my lord. They have submitted some medical documents. Otherwise, your lordship was earlier pleased to reject the bail petition of the
It is
petitioner. my lord.
43 days, Lordship, and even yesterday also, further condition was bad, and this is has been advised. Probably there is a stroke condition. What 43 days has been passed, Lordship, to date. In fact, he was picked up on 4th. So if we count from 4th, then it is 44 days. Length.
Yes, you have earlier submitted that 2 vehicles in questions they have already been recovered.
Yes, my lord. Otherwise, there are other cases also pending against accused. In this case also, my lord, there are other affairs filed by the, my lord, victimized persons, my lord, against the present petitioner and one Rupjyoti Das, my lord. And my lord, same modus operandi, my lord, they are involved in committing this type of offense, my lord, not only with the present informant,
Apart from this,
some other
it's
persons
not been
also, my lord.
registered, Lordship. Been registered,
Those are not
Lordship.
required to be regarding the present case, my lord, after knowing about the present case.
Present case, Lordship, present
persons,
vehicle
my lord.
has been recovered, Lordship. And other case has
In
not been
other
registered.
police stations also, my lord, on that day, she pointed out that
Yes,
Bushisto
Lord.
PS also.
Yes, I've given
And
the
in
bail
this-
order, Lordship.
And in this case also, my lord, those supplementary affairs, some of the, my lord, complaint filed by some of the victimized persons against depends on my.
He's saying those affairs are not yet registered.
Lordship, not yet registered.
Those are actually, my lord, treated because, my lord, in the present, why not registered, my lord? Otherwise,
There are certain
maybe
paper, there are certain rules, Lordship. Yes. There are certain rules that to be followed,
after
Lordship.
lodging of the present case, my lord.
Because on this affair, present affair, that has been registered, and those vehicles
Those are part of
mentioned
the
in
present CD, my lord.
maybe, Lordship, but
Those are the part of
Those are part of the present record in the present CD, my lord. Because after lodging of the same police station, my lord.
the same police station, the other affairs have been lodged.
Yes, ma'am. Not, those are not registered, but complaints filed by the other, my lord, victimized persons, my lord. Those.
let the police take
And against the present accused person in other police, Bosisto police station also cases pending.
place the bail order, Lordship, by filing additional affidavit. I have placed that, I have brought that on record, Lordship, that he has been granted, considering the fact that vehicle in question has already been, and in fact, petitioner, he is, in fact, he and his family members are also victim, Lordship. His own vehicle being entrusted to Rupjyoti, Lordship, on the situation that he was paying high monthly rental, Lordship. So all of them provided, Lordship. In fact, he himself written affair, Lordship, for recovery of those, Lordship, from Rupjyoti. That is the situation, Lordship. As a victim of circumstance, Lordship. He's having a reputed firm which deals with the uniform of the student HRA. I have annexed the
Yes, that business only.
Yes.
Why after all these things?
Okay,
Lordship. So
If
Rupjyoti.
they have farm,
Rupjyoti, Lordship.
good only.
He is accused number. He is already.
When we are in custody?
Lordship, if we count from 4th, because 4th was picked up by the police. So in that count 44, otherwise 43 lordship, counting from
Custody since 5 to 26.
5 to 26 and 9-day police remand, thorough police remand lordship.
RMST soon and it constitutes that represent that under will be scope. But the present fire has been the present petition is lost only on the specific ground of illness who is suffering from various old aged illness, and there is no one look after his age. But from that cases, the accused petitioner is interested since 3 days, including 9 days police remand, where I got sufficient opportunity to interrogate the witness. But the case is submitted that the which are in question. The vehicles which are in question have already been during investigation, which the vehicles related to the case had been recovered during investigation, but there are many complaints made by victims against these petitioners with similar kind of allegations, wherein also the modus operandi of the petitioner same. Those matters are also still under investigation. In the investigation is submitted, there is no new ground considering present bail application, which has under the scope on hearings. Here there is bills against petition and put the police for recovery of those 2 vehicles while he was in district. However, only considering the ground by the petitioner in reference to the element of this file and this service the confidential, which has already been taken. This code is its directions for his cooperation in the further investigation. Whose satisfaction it has been?
CGM Kamrup lordship.
CGM Kamrup.
I'm so grateful, highly obliged lordship.
Yes, timing to mark.
Well, 11, well, although till now I am trying to get the instruction, but well,
Have you received?
well, let her
Lordship.
record his statement that Sarshi wants to withdraw the case.
Lordship, I may be allowed, I may be given liberty to file, to approach the trial court, Lordship.
Maybe recorded, well, she submit the Sarshi submit.
You are MSF. You are Mr. MSF Ahmed. But it's hard MSF. You done it counts for the petition. Mr. Keyboard. Submitted by Ms. Ahmed that the available information has been that the case has already been charged against the petitioner, and accordingly she submitted that she may be allowed to withdraw the same, and the liberty may also be given which the running trial court next part, Mr. Board, the running information in regards to submission of charge. Next, we are considering the submission made by the prayer for the petition for withdrawal is thereby the matter is accordingly disposed of, disposed of withdrawal, and the petitioner is always at liberty to approach the appropriate court with appropriate the present diplomat. Yes, Protocol 12.
My lord,
for
yes,
this-
as per my instruction, my lord, sir, IO, my lord, he has newly taken charge of the case, my lord, as per his, but I have gone through the CD, my lord. And from the KJ, my lord, till now, the informant of the present case has not identified, and the, my lord, gold chain was not yet, my lord, taken Zimma by him. He has also not yet identified that this chain is of me, my. And regarding that aspect, there is no note in the CD. Only considering, my lord, length of detention, my lord. There are materials against the accused person. He is involved in
They admitted that this
habitual
sexual
offender, habitually involved in committing this.
parliamentary and it keyboard in addition to disseminate submitted by MS Tekka that the petition custody since and for the chain which is alleged to have been snatched by the petitioner is also during the investigation. Hence, the further be submitted that that some of the gold ornaments were recovered from Polsno. That is one shop owner. But till that, as per information he received from the the informant has not identified the gold chain and is not the he has not taken Jimma or the further he submitted the petition which it's only on the levels and this is a case from which place?
This
Peaceful PSP.
CJM
CJM Kamrup met.
obliged.
May we please, my lordship?
Yes. Yes, what is
This is
left?
the allegation under section
See,
103.
Yes.
My lordship, find the affair in page number 9, my lordship. May I read?
Page number 9.
9, my lordship. With due respect, I beg to state that my son, namely Loincho got married with accused number 1. 15 years ago, after getting married, they had been enjoying happy life. But about 2 months ago, driving the wicked advice of other accused persons, accused number 1 ran away from my son's house to her father's house. Accused person with pre-planning called my son of her telephone on 8/11/2025 to come to the house of the accused person, and on 9/11/2025 at 8 p.m. accused person assaulted him and he sustained serious injury. He was taken to the hospital in an unconscious condition for his treatment, but it has come to know that he died here. And accordingly, affair was registered under section 61(2), subsection 2, slash and 103, subsection 1, BNSS. Here the 4 persons has been implicated as accused persons, and all of them are in-laws of deceased person. This is the accused person number one is the wife of the deceased, and accused number two is the brother-in-law of deceased, and accused number three is sister-in-law, and accused number four is
You
mother-in-law.
have not applied for bail for number two.
Number two has arrested,
arrested.
already arrested, and he was already released on bail in default bail. My lord. My humble submission so far affair is concerned, here the deceased person is a heavy swill drinker, my lordship. On this occasion, he came with heavy drinks, and he was not in position to stand up and fell down and got injury. And at that moment, the accused person took them to the hospital, and he was declared dead, my lordship. The sofa affair also.
Who took him hospital? You, by the accused person?
Accused person.
They took.
Yes, the accused person.
My lord, here I have received the case there, my lord. And from the PM report, my lord, it was final opinion is yet to be received, my lord. Regarding the cause of death is kept pending till receipt of the chemical examination from PFSL kindly para, my lord. PFSL kindly para, my lord.
That is awaited. What is
Em-
the injury otherwise?
My lord, otherwise, my lord, as from the my lord PM report, my lord, I have not found any injury at that time, my lord. And one important thing is that, my lord, here only 9 years old child is the, my lord, 9 years old child of the disease, my lord. He was the eyewitness. My lord. Here in her 183 statement and 180 statement. Kindly bear with me. As per her statement, my lord, Sirojit Das, who was arrested, my lord, he has assaulted his her father, my lord. This is my lord, with a bamboo, my lord. For that, he was died, my lord. Let me kindly bear with me.
The accused person has already been arrested and released on bail.
And 180 statement, part 180. What?
submitted this accused petition. It is the fact that the deceased has and he was a and he used to torture her, getting drink. Therefore, she left house of the deceased and started staying with the in her parents. Day of incident, having drink, he came to the house. Sleep. Has been introduced to the accused petitioners took him to the court. He was declared yes. It seemed that there was a quarrel between the petitioner and petitioner number one and the deceased. And on the day of incident also, the one of the accused number two in the one Siranjit one Siranjit group had basically assaulted the deceased with his the 9-year-old child with the argument. And during the okay, you are granted.
PM report regarding the PM report one line mallet. PM report is yet to be mallet. Final opinion is yet to be.
Somewhat sometime 2 days PM report, but this final opinion is yet to be received as FSL report is still coming. It's a laboratory.
That's a dispose of.
This
Must open.
there will be some conditions, Mr. Thakuri, after all this.
Yes.
Maybe Jyoti, kindly matter may be taken up from sometime.
My lord, here some mistake on our part, my lord. In the last occasion, my lord, 2 cities were called for. Here, my lord, North Lakhimpur 417 and 418.
North Lakhimpur.
PS case number 417 and 418. Here, we have received one report from the IO that charge sheet submitted in North Lakhimpur 417 of 2025. But inadvertently, our colleague submitted that charge sheet submitted in the present 418 of 25. That's why Lordship was pleased to call for a scanned copy of the record matter. But from the verification, I have found, my lord, from the verification of the record, it was found that CD is available in our office, my lord. At present, CD is available.
CD with you now.
My lord, with me, my lord.
So we can peruse the case there.
My lord. Inadvertently, it was called for a scan copy, my lord. We have also submitted that charge sheet submitted, but charge sheet submitted in the cross case, my lord. It was mistake from our part, my lord. At present, CD is available with us.
So we can peruse the case there.
My
What date maybe?
You want short date?
if they want today also itself, I have also done record.
Yes, what to say? Two to maybe difficult.
They are already in interim, my lord. No problem, my lord. And CD also.
You are already in trip.
My lord.
Monday, my lord.
Monday.
Monday or Tuesday.
Okay, then Monday.
Lordship may correct it.
Yes, yes. You are Mr.
AK Das.
Huh?
AK Das.
Your name is not here.
On behalf of SCBs.
Your name was LK Das.
AK Das.
LK Das appearing on behalf of Mr. SCB. It is submitted by Mr. Shmu that inadvertently the submission was made on suspicion that the present case has already been charged and for which a scan copy of the TCR was called. In inquiry, it is found that the cross case has already been charged, not the present case, not the present. However, in the office, the CD of the present case was available in the case which is produced. However, Mr. Dilan appearing with Mr. Biswas paid for a short notation. The office let the matter be listed on 23 so and so CD be written technical listing. Interim be continued.
Okay.
What is 21?
May I please, Lordship?
Justice. 21 you received the case date.
Interim, my lord. Here.
Yeah, my lord, detailed report was called for, my lord. I filed this case against the GD entry, my lord. Detailed report was called for, my lord.
Report not received, my lord.
Report not.
For getting the, my lord, interim, my lord, the petitioner appeared before the IO also on 27 February, my lord. And he had recorded his statements also, my lord. But the police did not provide the case number, my lord.
But for your information, when you visited to the police station for recording of your statement,
Yes.
you get the information regarding the registration of the case?
Yes. We went to the police station, my lord, after getting the entry, my lord.
Yes.
Thereafter, they recorded the statement, but they did not provide the, my lord, case number, my lord. We asked for case number.
No, recorded the statement is okay. I'm just asking them whether registration of the case, do you have any information?
They said that
Yes,
on 26th, they have registered a case, my lord.
Achha.
They intimated, my lord, but they did not provide the case number, my lord.
Anyway, okay. Our Mr. A. Havari Tilan, for the petition. Mr. P. Sharma Tilan, BP appearing. Is submitted by Mr. Report of order of inspection dated 25/0. They have already appeared before the IO and their statements are also recorded. But the petitioners were not provided with the number under which the case has been raised. In view of this, let the reminder be issued, directing the IO to furnish the report. Yes, when it
They are interim, my lord. Second, man. Second again.
2nd of April, interim be continued to the
Employment.
May I please, Lordship? Application under 524, washing of the search sheet, Lordship. The scan copy was confirmed, also it has come. Basically, 2 witnesses, Lordship, out of 5 witnesses.
looking up this one, item number 9.
Yes, well, scan copy of PCR.
It has been received. For the cause this, it is shown.
Yes.
Scan copy.
Have you gone through the case record? The scan copy already received.
Received. I will have to go through it.
Only 2 witnesses, nobody has stated my name. Earlier also, Lordship has seen it.
This
Regarding
relates to, my lord, supplying of
blankets
fake-
with
fake-
on the basis of fake order.
fake work order, my lord. My investigation is search sheet.
Search it. I am challenging the search it.
Search not yet framed, my lord.
Challenging the search it.
It's okay, Sarge is not in. Have you gone through the case
No,
recording?
my
Is
lord,
that-
today I have not gone through the test.
Charge not yet framed.
Charge noted. The next date is on 23/4. Next week, you also may take 23/4. That'll be good. Next week, also fix it if he has not gone to the scan copy.
Yes, what to say?
Yes,
when it can be done. Because this week,
And
2
internal,
weeks, there are many
next week,
matters.
what?
Next week, my lord, civil,
If possible, when?
otherwise.
On a hearing there, he may take, I don't Thursday. Thursday or
31st will do.
31st, yes.
31st of March.
Yes.
Mr. T. Talukdar, Delegate Mr. P. Board. The scanned copy of the TCR has already been awaited support. Required some good. In view of this, let the matter be accordingly listed at 1 in addition.
Yeah.
May I please your lordship?
Yes.
My lord.
Oh, yeah.
May I please your lordship? Lordship,
Amicus.
lordship,
You are with amicus.
I am on behalf of the learned amicus curiae, lordship. Lordship, I have there are certain pages missing in this in this appeal, lordship. We have just received it on 16th of March, and there are certain pages that are missing in this appeal.
You're
lordship.
saying that your this copy supplied to you is not complete.
No, lordship. Lordship, and also to argue this matter, certain PCI will also be required, lordship.
PCI is there.
The TCR is there. If you want to file any your written objection, that is other aspect. Otherwise, because they are insisting on criminal appeal, I mean, one I is there most probably.
Yes,
it is connection with the suspension of sentence and all.
Yes.
So if you want to submit any your this objection in written form, that is up to you. Otherwise, this is available with us. And however, you are saying that your petition is not complete.
Yes, lordship.
So why you have submitted this?
My lord, registry has supplied it. Not.
Oh, sorry, registry has supplied. Which better take it out. This supplied with RMS RSDOT data and account. MS, URMS?
S not on behalf of Dr.
S not appearing on repeat and MX. Is submitted by MS that the copy of the petition is provided to the learned amicus, but it is not a complete one, hence the registry will be directed to furnish a complete copy of the petition. In regards to objection, do you want any time for objection? Otherwise, you can go through the record and can raise your submission.
Yes, lordship. Once I receive the full copy, then lordship may give me some time to file an objection.
No, that is not
My lord,
then
already,
it will
my lord,
be
half of the
yes.
punishment, my lord.
Yes, it will be again delayed.
5 years.
Because
Lordship, then
the petitioner is in custody, na?
Yes, my lord.
then
3
if
years,
if
5
it's,
months, my lord.
a short date may be fixed, lordship. Till then, the copy will be received and we'll be able to prepare it, lordship. If there is any objection to be filed, lordship.
Further submitted that they will also file their objection after receipt of the copy from the registry concerned. Registry. In view of this, the registry is hereby directed to furnish a complete copy of the petition, and letter may be fixed on 2nd of April. Will do. Within that period, you can file your written objection, if any. 2nd April, enabling the petitioner, enabling the respondent number to file his her written objection. And state you are not going to file, you can submit from
My
here.
lord, 5 years conviction will submit from our.
Otherwise, also case is ready, I think.
Yes, yes, ready, my lord. That's why I am also saying to council, my lord.
Can be
It may
listed
be for final hearing, my lord.
Yes.
5 years for the conviction, my lord. Already half of the
Half of the
punishment.
punishment has already
My
gone.
lord.
Yes.
So, further considering the submission made by we say that the SD this year has already been received. The service is completed and the case is ready for hearing. Also, the registry accordingly directed to release the matter for final hearing on 2nd of April.
Obliged.
Yes, someone had said one regarding one affidavit. Affidavit, who filed the affidavit? We have received the affidavit in morning hours. One submission was made on behalf of whom I don't know.
আপুনি কৰিছে ন? affidavit.
কোনে কৰিছে? The respondent side.
No, we are the petitioner, my lord.
কোনে দিছে? Affidavitখন কোনে দিছে?
Well, we have filed an additional affidavit, my lord.
তেওঁলোক applicant.
Take one second.
তেওঁলোকে ইফালে
It is available, my lord, now.
কোনে কোনফালে থিয় হৈছে? নহয় নহয়, তেওঁলোক কোন? যিবোৰ petitioner. এইটো
IA has been filed by them, my lord. The respondent number 2 has filed the IA. That is for vacating the interim order. And my lord, what happened, my lord?
আচ্ছা, against the interim order, who filed now affidavit? You have filed.
For additional affidavit, we have filed. To bring some facts to the record, my lord.
No, initially the petition was filed by you for quashing or what?
For quashing.
And then in that case, you got an interim.
Interim.
So
And
now they have
filed the
come for
interlocutory
vacation of the interim.
They have filed the interlocutory application for vacating or modification of this
And
order.
you filed the affidavit in reply or in additional?
No, additional affidavit.
Additional affidavit in which case?
In the main,
RAI?
in the main case.
Oh, in the main petition.
Main case.
Oh, in main petition also this. Even I did it.
My lords, my senior is on his legs in a different court.
In which court?
In court 1, so if the matter may be passed over for the time being.
Now see, at 2, it may be difficult.
Well, Theo,
Because we have only one, where the court will sit for 1 hour, and that too, some matters have been already fixed at 2 p.m.
And 3:15 my lord, report will write.
Yes, so 2 p.m. may not be possible.
My lord, one thing, my lord.
Then the date may be fixed.
My lord, one thing, my lord, what happened? Lordship's order 15/9/2025, my lord. It was observed that, my lord, he has already submitted, my lord, that the entire matter may be heard in spite of the interlocutory application, my lord. That is recorded at on Lordship order dated 15/9/2025.
In criminal petition
In the
or in I.
main case, my lord. Therefore, my lord, my humble submission before your lordship, entire case may be fixed for admission hearing, and his IA may be taken up as a written objection, and accordingly, entire matter may be heard, my lord.
That can be done.
It will be better in the next week of April, my lord. Today is not possible.
It is 15/5 or 25 or. No, last order. That order. In which date order you have passed?
My lords, in the IA, you'll find the annexure 15/9/25, annexure A.
No. That is 15/9/2025.
9.
15/9/2025. 15/5.
Why you are submitting so much? This order has been passed, Honorable Justice Midul Kumar Kolika. I had assigned all a main case of the. This is the order. Lord.
Yes, one order is there, Mr. Counsel, on 15/9/2025, that this interlocutory application wise pending time for interlocutory, both let the matter be finally heard.
Yes.
It may be listed in the admission.
Yes.
it can be listed in the admission column.
Yes.
Then it will reach also.
Yes.
Sometimes it happens then even if the matter is fixed in hearing column, it may not reach. So admission will generally reach the matter.
Yes, ma'am.
So let it be on admission column. We can hear the matter, your interlocutory for vacation, as well as in the admission column. If it is registered, then it can be finally disposed of.
Yes, ma'am.
Okay.
That is that may pair was made by them, ma'am.
Pardon?
That pair was made by them, my lord. On the basis
Or
of
made
their-
by them only.
Yes.
Acha. Okay. So now you are the petitioner, na?
And the petitioner, he is the applicant, my lord.
ऐसे मिला लिखे लिखे देखिए criminal petition for Mr. T. Borua is the petitioner. Your good name?
S. Barua on behalf of Mr. Arjidas.
S. Borua appearing for Mr. Arjedas. In view of order passed in I criminal in connection with this case, dated 15/9/2025. Let the interlocutory application be heard along with the connected criminal petition number 396 of 2020, and matter may be accordingly listed in the condition. In view of this, registry is hereby directed to list the matter for revision. So that matter can be heard.
22 নলবা বেলেগ date.
Okay, well, listing it on admission column, registry is accordingly directed to list the matter. You want any fixed date here?
Well, after vacation 23rd, 24th.
But you are enjoying the interim, that is their case.
I mean the interim, my lord. It's up to him, my lord.
Yes, what do you want to submit? Because your petition, your case is that they are enjoying the interim, so you are paying for vacation of the interim order, isn't it? So they are paying that after vacation, that will be on the 23rd. Are you agree on that, or you want any prior?
Manoj, I mean, short date may be given because that is what my senior had instructed.
1st of April, is that?
1st of April, 2nd of April.
2nd of April? Second.
By interim may be continued.
2nd of April, interim be continued till let's say. So we are giving short date on 2nd of April. It will be listed in the admission column. Go for it.
Entire case. Oblige you.
I apologize for mentioning item number 24, which had just been taken up now. My colleague had mentioned
Yes, he had already
on
mentioned.
2nd April. My prayer is, Lordship, on 2nd April, I won't be in station. So if it could be on 9th April, I have taken the consent of the appellant counsel also. And
Council, you have taken consent?
yes, she's here.
Yes,
Okay.
And Lordship, one more prayer with this memo of appeal which has been served upon us.
It's not
It only contains the judgment. Solely on the basis of judgment, I will not.
We have
be
already
able to
passed the
argue
direction to the registry to provide you the complete copy.
not only the complete copy of appeal, Lordship, the depositions of before the learned trial
No,
court,
we have not
the
made any
medical report.
paper book. Paper book is not.
Paper book is not there, Lordship. In other cases, what I have received is the relevant documents from the TCR are provided.
Relevant documents. Okay,
Because
we'll provide.
In order to argue the appeal, the entire documents will have to be appreciated by this honorable court.
Oh, 9 is a holiday.
Lordship, 9th, I have got some fixed matter.
Election is there 9th. So it will be a holiday.
Then, Lordship, 7th, it will not be possible for me, and 2nd, I'm not here. The problem is that 7th.
But their case is that the petitioner is in behind the bar, appellant, sorry, is behind the bar for most of half of the sentence. He is already behind the bar. So
I have simply received the copies 3 days ago, Lordship, and that.
No, I can understand. Just we are stating that if it is on second Queensland, huh? You're 7
in station.
Then if it is on 7th, you have
7th,
some problem.
Lordship, I have matter fixed in Meghalaya High Court, Division Bench of this court, CBI court. So if I don't reach for hearing, I don't want to seek an adjournment and delay the case. That is my only.
Yes, what do you want to submit? Before Bihu, most probably she has some problem.
Yes, ma'am.
Okay.
In order to prepare the appeal, also to study the appeal, and then if any judgments are required, I will need some.
Will you be able to on 8th of April? Will it be possible?
Yes, Lordship, 8th of April.
8th of April. Okay. 8th of April. Okay. We're listing it on 8th of April.
Yes, sir. Please, Lordship.
Regarding item number 9, my lord, your lordship admission, your lordship has fixed it on 31st of March, my lord, but I have gone through the scan copy. My lord, last portion of the CD not at all legible, my lord. Scan copy, my lord.
You place the matter on that.
On the previous.
Met your lordship.
You are on 26?
Lordship. Lordship, IA for consideration of bail, Lordship. Petitioner convicted under section 354, 506 and 8 of POCSO, sentenced for a period of 5 years. Lordship may consider he is in custody for more than 8 months.
I don't know. Yes, Madan, you are for as an amicus. Have you filed any?
I have seen the record. Husband was passed in 17 July 2025.
17th of July?
Last year.
Oh, acha.
It is only 8 months, 3
8 months.
Sentence is 5 years. If early hearing can be taken up, the entire matter can be
Minor.
because the victim's deposition has been annexed at page number 18. Man. He has implicated.
Otherwise, you have received it this year.
I have received the IA criminal copy.
No, IA is okay. TCR we have received.
TCR received, my lord. It is ready for hearing, my lord.
Let me finish the entire matter will dispose of.
Mr. Alamuch, Learned Counsel, Mr. B. Sharma, the Learned Edition PP, appearing on Mr. N. Mahajan, the Learned Amicus, appearing for the Learned Amicus, appearing for the response. It is submitted by Mr. Mahajan Sharma that as the case record, as the TCR has already been received and case is ready for hearing, and that report, the petitioner is behind the bar since the date of judgment, that is from 17/7. In view of this, that the matter be accordingly listed for final hearing. Raised is hereby directed to list the matter accordingly.
After Bihu, my lord,
It will be after
22nd.
Bihu only, because prior Bihu we don't have any.
My lord, 23rd, my lord.
Okay, then 23rd.
23rd.
Like.
I will be heard. Cannot be governance. Hearing it. Repeat.
For hearing 27 and 28.
It is part. Yep. Disseminate accordingly. Fix.
May please, lordship. The arguing counsel for respondent number 2 is unable to be present over it. May a date be fixed for this?
Respondent number 2.
Right.
Mr. Sahibwala was there. You are for the appellate?
Yes, Lordship. Lordship, a date name.
You are Mr. J. Khalid.
Yes.
And you are Mr.
A.R. Pal for M. Sahibwala.
A. Abbas.
A.R. Pal.
A.R. Pal appearing on Mr. M. Sahibwala for the respondent. Wait for an action, which we done it also the record. You want any fixed date here or
22nd or 23rd of April?
Many matters have been fixed on 23rd.
20?
28th of April will do. Tuesday is a hearing day.
Okay, Lordship. Obliged.
Obliged.
That is the lordship, my lord. Your lordship, remember, my lord, this enact case, my lord, they have challenged, my lord. In the meantime, they are making some payment, my lord. Last time, your lordship directed to give instruction, my lord. In the meantime, they paid some amount. Thing is that, my lord, since strong order would be necessary, because it is in hearing matter. So it is coming in hearing, that is why it is coming on the hearing column. Actually, had it been in orders or everything, it would be better.
Oh,
Your Honor, already there is an amount of 2,50,000 that was awarded, and we have already paid an amount of 1,45,000.
1,40,000.
1,45,000 has already been paid, and 1,05,000 is pending. So within the due course of time, we will pay. We are paying in installments to them, and we will pay it as soon as possible.
So,
long time.
as per you, it may be listed in the order column.
Yes, that would be
It will
better.
be
That will
better,
reach early.
Yes, sir.
Card MS RR. You are
RR Mujib.
MS RR Mujib done and also but Mr. P. Water Putilan additional PPF in India respondent number and Mr. A. Busru at the Planet Council appearing for the response. It is submitted by both the parties that the some amount of the awarded amount has already been paid by the accused petition, and it is submitted by MS Mujib that already 1,45,000 has been paid, which is also accepted by the learned counsel Mr. Busru for the respondent. However, it is submitted by both the parties that matter may be listed in the order column. In the meantime, some further payment may be possibility of further payment is also there. Considering this submission made by learned counsel for both sides, the registry is hereby directed to list the matter in order column on next date of listing. You want any fixed date here or?
Yes, fixed date would be better.
How many?
After Bihu, if-
Because you are making payments, so that's why I'm asking you.
Yes, Your Lordship. After Bihu, if it is
Bihu.
fixed.
Yes. 22nd of April?
Yes.
22nd. Please take over.
Oblige you.
Oblige.
You to partner, please promote. Now, this matter was fixed at 2 p.m.
Yes.
I can see. But what is the problem? You are for the respondent.
I am for the respondent.
Other side may also come at 2 p.m. That may be there. Just I'm explaining you the position, because within 1 hour, I don't know, it may not be possible to hear the matter.
Matter is a short matter actually.
Okay.
were
Because
expected-
3 or 3:10 we have to rise.
Actually, there was no mention of the check number in the legal notice. In the
Whatever, the question is there, I can understand. Now, if it can be completed by sharp by 1 hour, then it's okay.
not
Otherwise,
necessary one. Within half an hour, within 20 minutes or half an hour.
From your part only, the other side.
No, they was, my part is very easy part.
Okay, then we'll see to it.
Yes.
Otherwise, what I'm saying, because I don't want to keep the matter as a partner. I don't want to keep the matter as a partner. If it is sharp by before 2:50 or.
I'll be very short.
You'll be very short. Let them hear.
Yeah.
Because don't want to keep the matter as a partner.
Yeah.
That's all. Today we have only 1 hour in our hand after 2. So if it can be possible on our part, then. That's it. Who is the other counsel?
Mr. Sharma, H. Sharma.
H. Sharma. Your interlocutory application for suspending sentence and allowing him to go on bail, that has been rejected. However, it has been observed that endeavor shall be made to dispose of the connected appeal within a short period.
Oblige.
For hearing item number 30. May I please, Lordship? It is an appeal.
Before initiating your hearing, just I want to submit one thing.
Lordship,
We are shortage of time, so within
yes,
half an
yes.
hour, if it is
Within the
completed.
possible extent, I will make it short.
Because I don't want to keep it a part hard. That
Yes.
is the main issue.
Lordship, we both the parties have already submitted our respective written arguments.
They have
I-
already did?
Yes, respondent side have submitted in the year 2022,
Oh, acha.
and I and the appellant side,
Ah.
we have filed it in the year 2023.
Oh,
Both
these
the
are-
copies
these
we
are
have.
here?
Yes, both the
Copies over
copies
here?
in the record, Lordship.
এই রেকর্ডও আছে নাকি?
Lordship, it is there, respondent side. We have received it on 17th day of November 2022. এইটো হয়নে? Lordship, we had filed it
Mm.
in the year 2023 on 8th day of June. 8th day of June
Maybe
2023.
available, I am just checking.
Right.
Anyway, what is your case?
Yes, my case is, your Lordship, there was a liability was there on the part of the other side, and check was issued in the year 2017, Lordship. And accordingly, it was, Your Honor, it was deposited before the concerned bank for drawal. What's happening, Your Honor? It was dishonored by the concerned bank. Thereafter, we had filed a case under the relevant provision of the Enact, Your Honor.
So
Before
you have filed a case?
Yes, I have filed it. I am actually appellant complainant,
Oh, acha.
and they are the accused respondent, Lordship.
Okay.
Only one accused is there, Your Honor, and one complainant is there.
Okay.
Two points were determined by the learned judicial magistrate court. That was, one point was the legally liability was there or not. And that was, of course, decided against my interest, Your Honor. And second thing was that whether bank in fact dishonored the check or not. And that was, of course, in my favor. The concerned check of rupees 6 lakh, in fact, dishonored by the bank on lack of sufficient fund on the account of the accused respondent. And third issue, and third point, which was determined by the learned judicial magistrate court, was that whether demand notice were issued or not after immediately dishonor of the check. Learned trial court found that there was no demand notice was issued, and it was not in proper form. Demand notice was issued, but it was not in proper form. The particular amount which was in question, that was not demanded upon. That was the learned trial court's finding, Your Honor. And finding was recorded in the year 2018, and we immediately filed with a leave application before this Honorable High Court, criminal appeal. And after granting proper leave, the appeal is going on from the days of 19. Now it is almost 7 years old, Lordship. That's why I had mentioned it. Accordingly, it has been listed at 2. Our basic ground for appeal is the evidence on record, which is found from the mouth of complainant, appellant, and also found from the respondent, accused, has not been appreciated in proper terms. And accordingly, it was decided against the interest of the appellant, Your Honor.
Evidence was not
Properly appreciated upon, Your Honor. What is recorded during the cross-examination stage, particularly cross-examination stage, we had extensively cross-examined the accused side, and my client, that is the complainant, was also extensively cross-examined by the other side. During cross-examination, the complainant was affirmed, so far the issuance of the check is concerned, against the particular liability of rupees 6 lakh. The question check amount was 6 lakh. And that was, he was affirmed, so far the signature of the accused is concerned, so far the issuance of the check is concerned. What's happened, Your Honor? There was a minor mistake in the complaint petition. It was wrongly asserted that the check dated was on 17. Actually, it should have been, actually it was wrongly inserted on 14, but it should have been 17. Check dated, in fact, in the year 2017. The case originated in the year 2017 itself, Your Honor. But it was wrongly explained, it was wrongly stated, inserted in the complaint petition that it should have been 14. Actually, it should not have been 14, it should have been 17. And that explanation has been given by the complainant himself while drafting his petition in the complaint petition itself, Your Honor. And that explanation has not reflected in the impugned order, Your Honor.
No, obviously there may be printing mistake. In your petition itself, there was a mistake, or in the check, the check in question bears the signature of 2014. That is the issue.
That is the issue. Yes, Lordship, yes. Exactly, Your Lordship has found. And that explanation is there in the complaint petition itself, Your Honor. Lordship may kindly see.
No, but you want to say that the check which is passed
Yes.
was dated so and so of 2014.
2014, actually, it should not be 14. It actually, in fact, 2017, Your Honor.
Whatever
And that
it
explanation is there.
ought to be 17.
Ought to be 7.
I am saying that whether the check bears if 2014 only.
Not 14 only, Your Honor, 17. Check itself was exhibited before a learned trial court on the basis of the question was asked. And it was shown at the time of exhibit. Before the learned trial court, it was shown. Yes,
Check will be exhibited.
yes, check was exhibited, concerned check. And it was shown other side also. And other side have admitted, yes, my signature is there in the concerned check. It is my signature. And the bank in question, that was also my bank. I had issued this check. This sort of evidence is there, Your Honor. Even then, Your Honor, the learned trial court did not found a case in favor of the appellant, Your Honor. That is the thing, Lordship.
Check.
Lordship may kindly see.
The exhibited check bears the signature of 2014 or 2017?
2017, Lordship. Check itself. I will show the check also, Your Lordship. Because it is an appeal, and appeal itself is Your Lordship will have to decide the facts and the questions also, which are involved in legal questions.
We have received the respondent side's argument. Your side is there also.
My side is also there in the year 2023. Yes. I had furnished one copy also to my colleague. That is the check in question, Lordship. Exhibit A. And here specifically mentions check dated 5/4/17. And it is his signature, the accused signature. And he has admitted during cross-examination, yes, it is my signature. When I showed it to him during the cross-examination, yes, my signature. And this amount is 6 lakhs. He has admitted this amount. And this person is, drawee is Dhiraj Sharma. Dhiraj Sharma was the complainant, Your Lord. And that fact is admitted during cross. I will come to the cross-examination portion. He has admitted that his account is at the State Bank of India. State Bank of India, Udayan Bihar branch, Kamrup, Gauhati.
We have found only the argument from the respondent side, not your one. If you have extra copy, you can submit to us.
Yes, Lord. Lordship, our evidence on record has been inserted in the leave application.
Just. Order no. Yes, Mr. Shah.
Yes, Lordship, our evidence, entire evidence is at the criminal leave petition file. Criminal leave petition file is there, 8/19. Evidences may be, Lordship, may be considered upon. I like to read out this portion, portion of the evidence,
Yes,
which support my case, Your Honor. Dhiraj Sharma, he was the complainant appellant. Apart from the instance say, that is Exhibit A, he specifically mentioned Exhibit A. The accused had given me the other 6. He had given me the other 6 as well. And it was not a fact that the accused had given me a blank check apart from the signature. The plea of the accused was there. It was a blank check. My signature was not there. But he, in fact, while facing the cross-examination, has categorically stated that it is not a fact that accused had given me a blank check apart from his signature. Apart from the instance check that is Exhibit A, accused had given me the other checks as well. He has given me other 6. In addition to this present check of rupees 6 lakhs. I had given demand notice for this check. That a trial court came to an erroneous finding that the demand notice was in proper, not in proper form. It was not demanded the amount in question, that is a rupees 6 lakhs. But in the demand notice itself, we have exhibited, that is exhibit C, it is specifically mentioned that yes, rupees 6 lakhs was involved, and that was demanded upon when the notice, when the check was concerned, check was refused by the concerned bank of the drawee. I had given demand notice for this check, that is exhibit A. I had not mentioned the check number in the demand notice. Yes, I had not mentioned the check number in the demand notice. But so far the demand notice is concerned, I like to show lordship. That is my demand notice, exhibit C. Here specifically mentioned notice addressed to Kokil Namasudra. Kokil Namasudra is the respondent here. Under section 138 of the NI, 30th day of May 2017, notice itself reflect that it was issued on 13th day of May 2017, notice itself. It was addressed to his proper address, Panikhaiti area, Gauhati, near Kali Mandir, under Chandrapur. Under the authority and instruction of my client, Dhiraj Sharma, this notice has been issued to you with the following instruction. In the discharge of your lawful liability, you had issued a check of rupees 6 lakhs only on dated 5/4/17. It was of course overwritten. It was of course overwritten, and it was took as a specific defect on the part of the complainant that you had overwritten this check dated. Actually, in fact, it was on 5/4/17. It was wrongly typed as 5/4/14, 5/4/2014. And it was subsequently correct upon your honor. It was shown, this check notice check was shown to him. And showing this check demand notice, question was asked to him. And he accordingly answered that yes, demand notice was sent on 30th day of May 2017. When evidences is there, evidence support the case of the concerned party, there is no question of coming to an erroneous finding, lordship. Dated was SBI Narangi branch. SBI Narangi branch was his branch, Joyous branch. Having received the check amount of rupees 6 lakh, that is the check in question, my client appeared to be much delighted, and it was immediately deposited in his account at Industrial Cooperative Bank, Gauhati branch. It was subsequently dishonored on 25th day of May 2017. I return memo dated. And Rani Triangle came to a finding, yes, Industrial Cooperative dishonored it on 25th day of May 2017. You are hereby requested to pay the said check amount. Said check amount means the check amount of rupees what is cited in the subject of the notice. It is exhibited, it was shown to him during cross-examination. Exhibit C, evidence from the side of complainant. In exhibit C, said number is 5/4/17. It is not check number. It should have been recorded. Evidence should have been recorded as check dated 5/4/17. What is stated in the demand notice? Which is overwritten. Yes, it is overwritten. Which is overwritten. On the type date was 5/4/14. It was simple clerical mistake. That's why it was overwritten by offense 17. Because date itself mentioned the 17. Notice itself mentioned from the date of 13th day of May 2017. It is not a fact that I have not given any demand notice. When the other side crossed him that you had not given this particular notice, he had categorically stated, complainant, appellant, that it is not a fact that I have not given this demand notice for this check, that is exhibit A. It is not a fact that I have sent a demand notice for that check dated 5/4/14. He categorically denied the defense plea, lordship. He categorically denied the defense plea that it is not a fact that I have sent a demand notice for the check amount of check dated 5/4/14. 5/4/14 is a different issue. So far, the 5/4/17 is concerned, that check notice has been given, and that check was dishonored, Your Honor. I am reading on the complainant's evidence. I have not mentioned the check number either in the demand notice and the complaint petition or in the evidence in affidavit. Check number was not mentioned, but check dated was mentioned. Check dated was 5/4/17. I have not mentioned in the complaint petition in para 3 that my lawyer had mentioned the date of check is 5/4/14 instead of 5/4/17 in the demand notice. I have not mentioned, means it is actually written. Lordship may kindly see our complaint petition. We have enclosed here it in a criminal appeal. The criminal appeal 84/19 at page number 15. At page number 15, para 3. We have specifically mentioned what bona fide mistake I had committed. I was the engaged advocate of the concerned party. What bona fide? It is explained to for the satisfaction of the learned judicial magistrate court that para 3 of the page 15, that on being much upset and frustrated, the complainant lawyer, through his engaged advocate, issued a demand notice on 30th day of May 2017. That is Exhibit C. Against the accused, asking for the said check amount of ₹6 lakhs within a period of 15 days from the date of receipt of this demand notice dated 30th day of May 2017. It was sent through registered post with AD. On bona fide mistake, my lawyer, the complainant has explained, on bona fide mistake, my lawyer mentioned the date of check out as 5/4/14. Date of check was mentioned in the particular notice 5/4/17 instead of actual date 5/4/17. That explanation is there, complaint petition itself. On the basis of that explanation, this question was asked by the my learned friend of the other side during cross-examination. He has stated that it is not a fact that I have not given any demand notice for this check. It is not a fact that I have sent a demand notice for the check dated 5/4/14. It is not a fact. I have sent a notice for 5/4/17, which was dishonored. That amount was 6 lakhs. It is not a fact that instant check was the blank check. Defense plea was there. It was not signed by them. It was a blank check. It is not a fact. Complainant stated during cross-examination that it is not a fact that the instant check was a blank check which was taken as security. It is their plea. My complainant has denied this thing during cross. It is not a fact that the accused had taken a loan of rupees 1 lakh and had returned rupees 1,48,000, which is inclusive of interest. It is their plea. The accused had taken a loan of rupees 1 lakh from the complainant and he has returned back with interest 1,48,000. It was denied. It is not a fact that a vice check number 18106 dated 5/12/14, rupees 53,000 and another amount of rupees 95,000 dated 6/70, the accused had paid the sum. It is not a fact. Complainant has denied during cross. It is not a fact that a check, that is Exhibit A, was given in the year 2014. Again, they ask question, this check amount, this check was given in the 14. My client has adequately denied this thing. It is not a fact that a check, that is Exhibit A, was given in the year 2014. The demand notice that Exhibit C issued by me does not bear the word I demand. But what I have exhibited here, that is Exhibit C, under this subsection, you are requested to refund the said amount of rupees, check amount, within 15 days. That means request was made. No doubt demand was not made, but request was made to refund back. Same thing, Your Honor. Here also, in the title page of the notice, it is written that refund of rupees 6 lakhs. That means you are hereby requested to refund back rupees 6 lakhs. But so far, examination and cross-examination of defense side is concerned. That is very important because my basic plea is that the evidence on record from the mouth of the both side, either side, was not appreciated upon in true sense. That Kokil Namosutra, he was the respondent. He had stated during shift that I had taken of rupees 1 lakh from Dhiraj Sharma. Dhiraj Sharma was the complainant for business purpose. That means monetary transaction was there. I had taken, the accused side has said that I had taken rupees 1 lakh from Dhiraj Sharma for business purpose. On 5/4/14, I took the amount from him. On 5/4/14, there was another transaction for rupees 1 lakh. Business transaction between the parties. He had taken my signature on the blank deed. He had taken the signature on blank deed against the submission of this 1 lakh rupees.
I can understand.
Yes. And took 3-4 blank checks. 3-4 blank checks was taken. I had only put my signature. Though he was asked question that no signature was there in the check concerned, but he has admitted during shift that I had only put my signatures. I have returned back the amount in 2 installments. On 6/12/14, I gave 53,000. On 6/6/16, I gave 95,000. Exhibit 1 is the passbook page of the accused. He has exhibited the passbook page of the concerned bank, from which bank he had. And Exhibit A1 is the relevant entry of the concerned transaction. Exhibit A2, counterfoil showing the transaction of 95,000. And that amount is quite different, so far the present amount is concerned. I am coming to that. I gave a total of rupees 1,28,000 in return to the complainant. He had took 1 lakh. Against that, he had given 1,28,000, including interest. After I returned the money, the checks and blank deeds were asked to return. After I returned the money, he had asked him to return back my blank checks, all these things. But he did not give. It gave to me on 21/6/17. I received a demand notice, legal notice from the counsel of the complainant. He has admitted during cross-examination that on 21/6/17, I received the legal notice from the counsel of the complainant. That means we issued the notice on 30th day of May 2017. He received the notice on 21 day of June 2017 in the subsequent month. Demanding rupees 6 lakhs. A demanding word is very much there. Demanding rupees 6 lakhs. He has admitted during his evidence the demanding rupees 6 lakhs. On 5/4/18, 5/4/18 was the date of the check. Actually, 5/4/18 was not the date of the check. 5/4/17 was the date of the check. Lordship, the check in question bears the date. It was exhibited 5/4/17. But he, during evidence, he said that on 5/4/18 was the date of the check. Actually, it was 5/4/17. Check itself was exhibited for the perusal of the court as well for the perusal of the other side also. Mentioned in the notice, the notice did not bear any check number. Notice did not bear any check number, but it was mentioned so far the date is concerned. Exhibit 3 is the legal notice dated 30th day of May 2017. He has exhibited. He has admitted. Exhibit 3 is the demand notice. Exhibit 3. And they have exhibited the demand notice also, which they have received from the side of the complainant, Your Honor. Before institution, right? He has exhibited. The Exhibit 3 is a legal notice dated 30th day of May 2017. Exhibit 3. On cross-examination, he has admitted the whole case of the complainant. Lordship may kindly see. Exhibit A is a check. He was shown during cross-examination whether it is check or not, concerned check. He has admitted that Exhibit A is a check. Exhibit A is my signature. Exhibit A1 his signature.
Admitted, yes.
Exhibit A mentioned that it is rupees 6 lakhs. Exhibit A mentioned that rupees 6 lakhs is mentioned. I have not taken any legal recourse to recover a blank check. It was his plea during shift that he has given certain blank check to the complainant side. But he has not taken. When I asked the question, have you taken any legal step to recover the blank checks? He has taken that. He has took the stand that I have not taken any legal recourse to recover the blank checks, blank deeds and blank checks from the Dhiraj Sharma. It is true, I had once given this check in Dhiraj Sharma. It is true, I had once given this check to Dhiraj Sharma. Dhiraj Sharma, he has given this check. Exhibit A mentions State Bank of India. It is his bank, State Bank of India. It was his bank. Narangi branch, it was his Narangi branch. Exhibit B is the return memo of the industrial bank. He has identified the return memo also. When it was deposited rupees 6 lakh, that was refused by the industrial Gauhati bank, Gauhati branch, and he has identified that yes, it is a return memo, concerned return memo. And it mentioned the fund insufficient. The legislative intention is fund must be insufficient to honor the check. And he has admitted during cross, yes, fund insufficient. Exhibit 3 is the legal notice. He has again identified the legal notice. Yes, it is the legal notice which I had received before institution of the case. Legal notice. And Exhibit D is the postal receipt. I had mentioned the postal receipt also exhibited, and he has identified, yes, my name is there. It is my postal receipt through which I had received the notice. And it bears my name, Kokil Namasudra. Postal receipt itself, it bears the name Kokil Namasudra. I have known the complainant for last 6-7 years. In the year 2017, 2018, while adducing evidence before the learned trial court, he has stated that I had business transaction with the complainant since last 6-7 years. I had contact with him. And till this case was filed, I had contact with him till this case is filed. The business transaction was for about 1 year. Business transaction for 1 year. I have not taken any legal recourse against this false and concocted. It was free, it was there. Case itself is a false and concocted. But I have not taken any legal recourse against me. I have not filed any defamation case or money suit against the complainant. I have not filed any defamation or money suit. I have not filed receipt from the Dhiraj Sharma for the money returned. What he has returned to me, against that he had not exhibited or he has not taken a legal step for the exhibit of that money receipt. There is no money receipt in fact. That's why he has said, I have not filed the receipt from Dhiraj Sharma for the money returned, as he had not given any receipt. His plea was that I had not given any receipt. But so far, cross-examination of complainant is concerned, no such evidences is there that any amount was returned back, and accordingly this exhibit was there. You had not submitted this exhibit, or either from the accused side or either from the other side, it was not given. That plea was not there. So far, the exhibit of the particular document, money receipt. Actually, in true sense, there is no money receipt. I have not asked for the money receipt since the case is going on. He has again stated that, accused side, since the case is going on, I have not asked for the money receipt. But so far, the other legal recourse is called, he has not taken the legal recourse. These two evidences are very important to decide this case, Your Honor, to appeal, to decide this appeal. So far, the others.
This is not the case. Question is that checks, signature in these checks are admitted.
Yes.
Undoubtedly. He issued the checks.
Yes.
The drawer banks or whatever, that is also admitted by him.
Yes, Lord.
His main plea was there that he gave some blank checks with
Yes.
his signatures.
Yes.
And that's why he admitted his signatures. With some blank checks, he given the signatures.
Yes.
Signatures, they are in the blank check.
Yes.
But their plea is that 1 lakh rupees was given through by him, and it was refunded. And admittedly, a check was issued on 5/4/2014.
Yes.
So now the question is, if any check is of 5/4/2014.
Yes, Lordship. And that check is exhibited.
Exhibited.
Yes,
Who
that
exhibited?
and accordingly he has admitted during cross.
Who exhibited 5/4/2017?
Yes, I had exhibited, Lordship.
5/4/2014.
I had it is my check.
Not 17. 5/4/2014.
It was not exhibited, Lordship. No check was there. From the defense side, no such check was exhibited. It was only there verbal plea. No such documentary plea was there.
That was not
Not there, Lordship. Yes, that is the thing. And second thing, Lordship, is there. I have two judgments in this case. When the amount is admitted, signature is admitted, issuance of check is also admitted, in spite of his defense
So
plea
where
that
from
on
you're saying amount is admitted?
yes, said amount is admitted, Lordship. Yes,
Check
this
amount
is the amount.
Not admitted. This is the check. If
Yes.
you show a check to a person,
Yeah, understand.
then
Yes.
is it a check? Yes, it is a check. Is it your signature? Yes, it is my signature.
Yes.
Here, whether it is written amount is 6 lakh, yes, it is 6 lakh.
Yes.
That it will be admitted. So what?
No, Lordship think is that this amount, which amount is mentioned in the check concern, he has stated that when it was shown that yes, there is financial transaction is there with that since last 6-7 years. And since last
Financial transaction was there. I can admit. Now the question is the checks, which check in question, he admitted his signature also. No
Yes,
dispute
yes.
about it.
Yes.
He issued the check, admittedly he issued the check, signatures are there. But his question is that he took rupees 1 lakh only.
Yes.
Now the question is that if you show him a check, then definitely he would say that this is a check, this is my signature, there's 6 lakhs is written there. That doesn't mean that he admitted that rupees 6 lakhs was transacted. Is
Lord-
there any such statement?
Yes, Lordship, that thing is there.
Okay, then you just show me.
the evidence of accused side,
Hmm.
recorded page number 42
Yes.
of the leave petition, page number 42 of the leave petition. It is in a leave petition, Lordship.
Okay.
Evidence portion as the
Leave
leave petition.
Leave petition. 42.
42 page number.
Yes, 42.
At leave petition page file and there.
Yes, yes,
Yes.
42, yes.
I had taken rupees 1 lakh from Dhiraj Sharma. Dhiraj Sharma was the complainant.
Hmm.
By Lordship.
Yes, 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 yes.
I had taken rupees 1 lakh from Dhiraj Sharma for business purpose. On 5/4/14, I took the amount from him. This amount was taken on 5/4/14. That was the defense plea. I had taken my signature on a blank deed. Lordship, I found problem.
Lord,
He had taken my signature on a blank deed, a blank, and took 3-4 blank checks. Lordship, I found problem. I had only put my signatures. I have returned back the amount in 2 installments. 2 installments. Amount was
Yes,
returned.
yes, you have already read
On
this one, yes.
that is rupees 53,000 and
Once in a 53 and
95,000. And accordingly, postal receipts and all these things are there. Bank transaction is there.
exhibited his some passbook also
Yes, that's it.
with that particular entry.
A particular entry.
Yes.
Below of this evidence,
We have already read this one.
yes,
What is
I have gave a total of rupees 1,28,000
Yes.
in return to the complainant. I had returned the money and checks and blank deeds were asked to return. But he did not give it back to me. On 21/6/17, I received a legal notice from the counsel of the complainant. On 21/6/17, probably Lordship.
It's admitted. These are admitted. No issue about it.
My Lordship, one important question they are not putting it, that Exhibit C and Exhibit 3 is different. Why we are exhibiting the same document? Why? We are not exhibiting the same document. They have saying that Exhibit C. They have exhibited C. That is the legal notice. And we have exhibited the Exhibit 3. Exhibit 3 is different. Lordship can go through the lower court records. There was no correction of the date. We have received on the legal notice, the date of the check was mentioned as 5/4/2014. The check date was mentioned. Clearly there. If Lordship go to the lower court record and get that exhibit, that document we have exhibited as 3 on Lordship. Lordship,
No, let him complete first.
Oh, yes, Lordship. Yes.
5/4/18 was the date of the say. Actually, it was a printing mistake on the part of the learned trial court. 5/4/17 was the date of sale. It is mentioned in the Exhibit A in the notice, and the notice did not bear any check number. Yes. Cross-examination. Exhibit A is the check, and Exhibit A is my signature. Exhibit A mentioned that it is rupees 1 lakh. With 6 lakhs. I have not taken any legal recourse to recover the blank check, blank checks, blank deeds from the Dhiraj Sharma. It is true that I had once given this check. to Dhiraj Sharma. He has admitted. Exhibit A mentions State Bank of India Narangi branch. Here his own branch, SBI Narangi branch, is mentioned. Exhibit B is the return memo of Industrial Cooperative Bank Gauhati branch, where my account is there. Exhibit C is the legal notice, and Exhibit D is the postal receipt, and it bears my name, Kokil Namasudra.
Yes, these are all
Entire
admitted.
facts are admitted, Lord.
No, these
This was the check it was issued from the side of.
No, you are misleading. These are all admitted. His checks is admitted, his return memo is admitted, notice is admitted, everything is admitted.
Yes, Lord.
And you have shown the demand notice. Yes, he also admitted in the demand notice, 6 lakh rupees, 6 lakhs was demanded, admitted. There's no dispute about it. Dispute is the check dated,
yes,
and dispute is that he returned 1,28,000. That is the dispute.
Yes.
So he is saying that the check which was issued by me, 3-4 checks I have issued, and out of it I have taken 1 lakh, and as a interest, with the interest I have returned 1,28,000 on 2 days. Date he has mentioned, and accordingly his postal account is also there,
yes,
to show that in these 2 dates this kind of amount was deposited in your account. So that is there. Now, that is the question. Now, what is your other submission?
Yes. Lordship, my submission, humble submission before the Lordship is there. As a transaction was admitted, and he has failed to submit any receipt, money receipt, against the concerned amount, that is a rupees 6 lakhs, Your Honor. He has not given any money receipt. When I asked question, have you given any money receipt from the side of, he has taken the plea that I have known the complainant for last 6-7 years. I have contact with him till this case is filed. Business transaction was for about 1 month, for about 1 year. I have not taken any legal recourse for this false and concocted case. I have not filed any defamation case or money suit against the complainant. I have not filed the receipt. I have not filed the receipt from the Dhiraj Sharma for the money return, as I had not given any receipt, as he had not given any receipt. I have not asked for the receipt since the case is pending. Since the case is pending, he should have taken a plea that yes, this is the money receipt during cross-examination. And you had put your signature here against receipt of this partial amount. Out of rupees 6 lakh, 1,28,000 is already.
No, that is not his case. Out of 6 lakhs, 1 lakh paid is not his case. His case is only 1 lakh.
Yes, that is.
It is not his case that out of 6 lakhs, I have paid 1,28,000. That is not his case. Don't try to distinct because
Yes,
it is
Lordship,
not his
against 1,28,000, they have submitted their postal entries
Yes.
as well as the bank transaction in their evidence on sheet.
Yes.
And that is quite different transactions, Your Honor. And so far my transaction is concerned,
He will admit your transaction. It is his transaction. He said that 1 lakh I have due, and with interest I return 1,28,000 in 2 days. 1 lakh whatever in 2 days, consequent 2 days. That these are the statement by which it can be proved that I have returned the money.
yes, yes.
So that is why he will admit your 6 lakhs. He will not admit. Definitely he will not admit.
Against that, I had given certain money receipt, but that money receipt was not exhibited, Lordship.
It is your case that you have given money receipt, but it is his case that you never issued any money receipt. That is his case. I'm not on other side.
Yes,
I'm
yes.
saying that it is his case that no money receipt was issued by you, and he did not ask for you also. That is his case.
I had not asked for the money receipt. He had not asked for the money receipt also. That evidence is there.
That is his case.
He had not asked for. Yes. Since the case is going on, if the case is going on, if the amount is already paid, he should have given the money receipt, Your Lordship. Yes, this amount is already paid. You cannot ask for a rupees 6 lakhs or like this.
That is your case. You have not issued any money receipt, or whether he had not asked. These are not the issue now at present. Now the question is why he has not asked money and why you have not issued the money receipt. That is may not be the exact subject matter of this case. But yes, obviously your demand is of 6 lakhs and he is not.
Actually, Lordship, we are praying before your Honorable High Court for fresh trial or to remand the issue on the basis of existing evidence also. To remand it to set aside the judgment and to remand the issue for fresh trials. So that entire points which are involved here, so far the issuance of stake in concern, so far the liability is concerned, can be decided afresh, Lordship. This is my submission.
Lordship,
Completed by 3.
Yes, Lordship, one important, very important ingredient under section 138 alia Act is the legal notice here, Lordship. Without legal notice, 130 will not go. Lordship, what they have issued, Exhibit 3. Lordship, in the Exhibit 3, is clearly mentioned that what we have got in the demand notice, Exhibit 3, that is the reason that we have exhibited. In the discharge of your lawful liability, written in the para A of that legal notice.
Which page?
In the discharge of your lawful liability.
Which page?
Page number 19.
This is not the exhibit. It's a exhibit 3 of the court below records. Exhibit 3. If
Lordship, we have admitted it. We have enclosed
the trial stage.
Page 19, Lordship, page 19.
Exhibit in the trial stage. At the very beginning, it's like a legal notice is like triggering the gun, Lordship. Once it is gone, Lordship. Otherwise, you have to you have to correct it and then give the legal notice to the accused. Once you have given legal notice, it's finished.
The legal notice.
Yes, exhibit 3 is the legal notice. That is I'm submitting, Lordship. That is the legal notice, exhibit 3. And what they have exhibited is the correct copy. They have corrected it at the exhibit C, as the exhibit C at the trial stage. But at the beginning, we have to get the legal notice. That is the reason the learned court below have
they
found
made
that
correction.
yes, have found that there was no legal notice. What issue was framed, that whether legal notice was issued. That was it.
In exhibit 3, date is 5/4/2014.
Yes, Lordship. Where it is mentioned that in the discharge of your lawful liability, you issued a check of rupees 6 lakhs only on 5/4/2014 drawn with SBI. That was not a corrected copy. What they have suppressed, that this fact was suppressed, Lordship. That ought to be corrected, and then they should have filed the case, Lordship. Without correcting and without issuing to the accused side, they have directly filed the case. That is the reason lower court below have found that there was no legal notice for this particular check. And the complainant side, it is evidence that apart from these checks, there were other checks also. Which on 5/4/2015, 3-4 checks were issued. For which check he have issued the legal notice? Date was 5/4/2014. There was no mention of the check number in the legal notice, in the complaint petition, in the evidence on record, in the evidence, affidavit on evidence. There was totally confusion of this case. Criminal case, this is a criminal case, Lordship. In a criminal case, prosecution has to prove the case beyond reasonable doubt. And the defense evidence is of preponderance of probability in the criminal case. So we have exhibited the 1A that we have submitted, we have deposited in his account. Check was deposited, and 95,000 was deposited in his account. There was mentioned exhibited 1A and 2. This exhibit is like civil nature. We have proved that we have deposited 1,48,000 with interest, whereas they have totally failed to prove their case. There was no legal notice. My humble submission, the first point is there was no legal notice, Lordship. This is one of the important ingredients. That is the reason lower court have found that this case that there was no legal notice. The issue was framed. This issue was framed, whether legal notice was issued, and there was no legal liability also. 2 issues was in my favor, and only 1 issue, that whether the check was bounced for insufficient fund. Insufficient fund, maybe insufficient fund. 3 issues was framed. This is the main point, Lordship. There was no legal notice actually. Exhibit 3 was there, but he have showed that exhibit C, ABC, C, and C is the corrected copy later on at the trial stage. At the trial stage, this will not do, Lordship. They have mentioned it at the trial stage, but not issued, not given to us. Legal notice should have been given to the drawer. Even if this court is sent to the lower court below, how the court will determine now? Legal notice, they have to say till now, till to date, they have not given us legal notice of this corrected copy. They have not given till date. How can the court determine now? 5/4/2014 is the date in my legal notice. This is my humble submission.
Lordship, what was recorded by the learned trial court below, that may be considered upon your honor. Page number 19. Page number 19 of the criminal leave petition. Page number 19. Page number 19 of the learned trial court finding. Page number 19 at criminal leave petition file. At criminal leave petition file, this there, page number 19 of the learned trial court's finding. So far the notice is concerned. In the instant case, page number 19, in the instant case is mentioned, page number 29, page number 19, paragraph 29 of the judgment, learned trial court's judgment. In the instant case, the typographical error was in the date of sale. instant case, in the notice itself, the typographical error was in the date of sale. Typographical error on the notice, and notice did not at all bear the SIC number. Notice at all did not bear the SIC number. Also, it is very clear that no subsequent notice was sent to the accused person by the complainant. No subsequent notice was sent by the complainant for this amount to the concerned person, accused person. Lordship, under section 138 NI, only one notice has to be sent. We cannot go for the subsequent notice.
Yeah, that cannot.
Yes. In Sumon Sethi versus Ajay Kumar Seriwal, 2000 Criminal Law 1391 SC judgment, Honorable Apex Court held that in the subsequent para, that is para 30 of the learned trial findings, held that it is a settled principle of law that notice has to be read as a whole. Notice has to be read as a whole, not partly, as a whole. Supreme Court judgment. In the notice, the demand has to be made for the said amount. What is the said amount? In the exhibit C itself, it was the said amount. Said amount. You are hereby requested to refund back the said amount of the SIC. Said amount of the SIC was rupees, in the first place, rupees 6 lakhs. As per person to the Apex Court judgment. Said amount. If no such demand is made, the notice has no doubt would fall short of the legal requirements. If no such demand is made, we have made the demand in the notice itself, that is exhibit C. Its copy was furnished to the other side. During cross-examination, they have put the question to the complainant that this notice, in fact, is not the proper notice, and it was not the proper notice, the actual notice which you had given to me at the time of filing the complaint before the London Magistrate Court. It was in fact not, no such plea was there from the side of other side. No such plea was there. No evidence is there from the side of the complainant or from the defense side, Your Honor. That in fact it is not the demand notice. It was the demand notice, no doubt. Some typographical mistake was there. It is admitted by the learned trial court. It should have been 5417, but instead of that, it was 5414. And that typographical mistake has been reflected in the judgment. And that judgment has been accordingly, in the light of the Apex Court judgment, the only one notice has to be given as per person to the 138 section of the NI, and that notice was given. And that amount, said amount, was demand upon the Honor. And it was requested upon to refund back. So there is ample scope for refund, Your Honor, to clarify certain points, if the other side has certain points, for fresh trial on the basis of existing evidence. Existing evidence, Your Honor. Then the trial will be short one, Your Honor, before the learned trial court. Is my humble prayer.
One judgment is also there, the Punjab High Court regarding that. However, surprisingly, the complainant served a legal notice to the accused for check number so and so, dated 26/9/90, which apparently was not for the check in dispute. It may be true that there was a typographical error in the said legal notice while typing out the check number, but such typographical error, if any, does not meet the compliance of the mandatory provision of 138 of the NI Act, and the only course left for the complainant was to give a fresh legal notice to the accused, which admittedly has not. In that case, the accused was acquitted, Your Lordship. Lordship, the recent Supreme Court judgment is also, today I have not remembered that, if the cause of action is there, legal notice can be given. Legal notice can be given 2 times, 3 times also. If that if the check amount is, date is there, validity date is there for 3 months, then within that 3 months, that legal notice can be given 1 times, 2 times, 3 times also. Recent Supreme Court judgment is there, but today I have got not. Yes, Lordship. I will furnish, Lord.
Lordship, I have 3 judgments. And one famous judgment is a Kalapani tax.
Furnish.
And Bir Singh. And so far the notice is concerned, I desire to submit one Apex Court judgment also. Appellant side, Lordship.
Yes. Yes, what do you want to show here?
Here, so far the liability of the stake amount is concerned, so far the admission of the stake amount is concerned, so far the admission of the notice is concerned, so far the admission of his signature is concerned, drawer signature, these three judgments will meet the requirement. And so far the notice is concerned, another judgment is the 2021 SCC.
Also submit, you can
Not today, Lordship.
submit to the court first.